They've been fixed, that headmaster's case. Tomorrow it is fixed. So let the matter be listed tomorrow, my lord. Hello, bless.
My lord, I have also similar prayer, my lord. This is admission matter, my lord. Last date is 28, so I will tomorrow, my lord.
What is it?
28 is the last day for admission, my lord. So that may be moved to tomorrow, my lord. Allowed to move.
58.
Admission, my lord. In B.Ed examination, B.Ed, my lord, course. After qualifying the, my lord, marks obtained in the entrance examination.
May it please your lordship. Lordship, with the consent of the counsels for the petitioner, lordship, I would to mention item number 12 to 17, lordship, this series matter. In this matter, lordship, the learned advisor was supposed to advance argument today, lordship. Perhaps the petitioner side, they have completed their argument, lordship. Due to some difficulty, lordship, lordship may fix the matter on 22nd, on Thursday, lordship.
Who appears for the petitioner?
Your Lordship, the series matter has been led by senior counsel, Mr. Kane Chaudhary, sir. And Lordship.
Ken Chaudhary.
So, yes, sir.
We have taken our consent, lordship.
Series matter, sir. Upon the argue point,
He wants some adjournment.
the respondents want adjournment, sir.
Oh, I am told Advocate General approach, that's why they want to take time.
On 22nd, lordship.
22nd, there will be some problem.
Yes, yes.
Lord.
Let me on some other day.
Then some
I have
other day,
problem.
lordship. Then some other day, lordship.
But Mr. Ken Chaudhary, learned senior counsel, assisted by Mr.
D.S. Dekka, Your Lordship.
D.S. Dekal, learned counsel for the petitioners. On request made on behalf of Mr. D. Saikia, learned Advocate General Assam. Please, the matter when
It has been the first week, my lord.
of September?
Yes, yes. Because next week, 26th is a holiday.
Ah,
Then 28, 29, all that is. It has been the first week.
give a date.
Lordship, September
It can be on 3rd, my lord.
3rd.
Is a Tuesday.
Tuesday. Much okay.
May it please your lordship, I beg to mention for listening of a contempt petition pending of the year 2023.
Okay. Okay. Second.
Right.
Lordship, I beg to mention for listing of a motion matter. Lordship, this ongoing headmaster cases. Tomorrow, the series matter are listed already. Lordship, we have filed on yesterday. This motion matter may be taken tomorrow, Lordship.
Okay.
Lordship, my another prayer in regard to item number 19 to 23, Lordship, IIT matter, Lordship, we have filed the affidavit, additional affidavit, Lordship. That may be called for.
Okay.
Obliged.
Please, my lordship, I beg to mention item number 2.
Item?
2.
Two.
Yes, lordship. Can this matter be fixed on 5th of September?
You are appearing for?
I'm appearing on behalf of respondent number 2 to 5.
For the Guwahati
PG
University, I
Fukan.
have got a petitioner.
Oh, you are for the petitioner?
Yes, ma'am.
Is it okay?
Actually, I have the option. Lordship, kindly fix the matter on 5th of September if possible. It's a hearing day.
Okay, heard Mr. T. Chakravarti, and counsel for the petitioner. On request made on behalf of Mr. P.G. Fukan and Standing Counsel Guwahati University. List on 51?
5th, Lordship.
5th. So
As part 3rd.
that's automatic.
Much obliged.
Obliged.
Item 37 of supplementary list. Motion.
Fukan. Oh, yeah. Yes, Government Advocate D.D. Barman. We wait for some time?
Yes, we'll wait for some.
Maybe she's stuck up
Maybe
in
she's in
the-
a stuck traffic. No problem.
38, 39.
May please your lordship. This is the order. This is the order dated 19/9/2008, lordship. You know, I'm agreed by the Indian order at page 37.
1 minute.
This is the lordship was made a query yesterday, lordship, whether there was an order of transfer on attachment. That was also in public interest, Lord.
Yes.
Now, this imperial order at page 37 was issued with a malafide intention, Lordship, because I have approached this honorable court and your Lordship was pleased to direct not to fill up the post of the headmaster of Durgavati Hindi LP school. Therefore, Lordship, I have been reverted back, Lordship. Absolutely malafide intention. Nothing colorable exercise of power, Lordship.
How do you say it's malafide?
Malafide because I have approached this honorable court. Therefore, I was informed by the headmaster why you have approached the Honorable Guwahati High Court. That was the contention of the headmaster. Why you have approached the Honorable Guwahati High Court, stalling the selection or appointment of in-charge principal, in-charge headmaster. And on 29, when I went to the office of the headmaster, he did not receive the copy of the certificate copy of the order passed by your lordship. Even the deputy instructor of school also did not receive. And instead, on 31/7/2024, I was reverted back.
Let me have the instruction, Lord.
In the meantime, Lordship, because I am hanging position, neither I can go there nor here.
Lordship,
This is an order of 31/7/2024.
Yes, Lord.
You are already reverted back, isn't it?
Reverted,
Already
but
reverted.
I have not joined what their Lordship.
Why?
Because I was not allowed to join.
let me have the instruction, Lordship.
When can you get your instruction?
Next week, Lordship.
In the meantime, till then, Lordship.
By the next week, I will have the instruction, Lordship.
Okay, heard Mr. R. Dar, learned counsel for the petition. Mr. B. N. Sharma, learned standing counsel. Elementary education prays for some time to enable him to receive instructions. Praise a lot. List the matter after 1 week.
Lordship, after 1 week,
After
Lordship.
one. How about the interim?
Lordship.
Lordship, next week, I will have the
No,
instruction. I will come up with the instruction.
till then. Go ahead.
Okay, till the next reasonable date, the order dated 31/7/20
Lordship, otherwise, status quo.
shall remain
Not status.
suspended. Stop. It is made clear that further extension of this interim order shall be subject to the instructions received by the Learned Standing Council, Elementary Education Department.
Deeply obliged.
40,
Oh,
Let the matter may kindly be passed over time being. My lord, otherwise the matter relates to, my lord, the filling of the post of associate professor, my lord, under agriculture, Assam Agriculture University, my lord. And I applied for that post, my lord, but they rejected my application on the ground that I have obtained my PhD degree as per, my lord, traditional system. However, there is no such requirement in the advertisement and there is no such requirement in the regulations, UGC regulations of 2009, my lord. So after my rejection, my lord, I have submitted an application before them, my lord. That lordship will find it. First, my lordship at page 38. This is the impugn order, my lord. Impugn letter, page 38. With reference to the subject cited above, I am directed to inform you that your application for the post of Associate Professor Aquatic Environment Management against advertised number so-and-so was rejected, as your PhD degree was done under traditional system and not under course credit system. Moreover, no marks were filled up by you in the column given for PhD. Also, no credit have been mentioned against the course in the mark sheet as reported by the screening committee. My lord, there is no report furnished to me, my lord, of the screening committee. And my lord, as I already stated, there is no requirement in the advertisement as well as the UGC regulations that for this post, I have to obtain my PhD degree on credit system. And another reason that has been assigned that I have not uploaded the marks, my lord, that lordship will find at page 42. Kindly turn to page 42. This is the certificate given to me by the University or Guwahati University authorities. Here in the chart, my lord, down below, that course number 101, research methodology. I was awarded grade B. Kindly turn to the next page, my lord. Page 43. This is the, my lord, conversion of formula. If I get grade B, then my mark will be from 51 to 65. As no specific mark was given to me, so my lord, I am not able to give what mark I had been given, my lord. So this was the part of my application form, and this was very much with them, my lord. So, my lord, my humble praise, my lord, the advertisement is going to be issued. The interview is going to be held for other post on 22nd, my lord. So, my lord, I may be also kindly be allowed to appear in the interview, my lord. This is my humble prayer, my lord. Since I have the eligibility for that post, my lord.
We'll file a response. Let him provisionally appear in the
Yes,
interview. We'll file a response because.
Yes, my lord.
But Mr. RM
RM Dekar.
Will issue notice,
Very well.
issue notice. Mr.
KP Pathak.
KP Pathak, your lordship.
KP Pathak, Standing Council,
I'm appearing on behalf of the respond numbers 1 and 2, Assam Agriculture.
Assam Agricultural University appears for respondents 1 and 2.
I am for Guwahati University.
And Mr. PG Fikon and Standing Council Guwahati University appears for respondent number 3. The notice and the respondents are complete. However, extra copies. Respondents are allowed to file their respective affidavits. List after 4 weeks or 3 weeks.
Lordship, 3 weeks, your lordship, because otherwise the election.
After 3 weeks, stop. Interim, comma. Which
Advertisement, my lord, will find at page 29, and a notification declaring the date, my lord, will find at page 35.
29.
Page 35. That
He has
B.
applied for associate professor in aquatic environment.
Yes, yes. That lordship will find at page 30. This is a part of the advertisement, associate professor in equivalent, aquatic environment management.
In the interim, the respondents are directed to permit the petitioner to appear for the interview for the post of assistant professor
In the discipline of aquatic environment
in the
management.
in the discipline of aquatic environment management, scheduled to be held on
22nd, my lord.
22nd of
This month.
August 2024.
Yes, ma'am.
Stop. However, are you going to fill up the post?
But it may be subject to the outcome of this petition.
Yes, my lord.
That will create a third party right again.
Only one candidate is there, my lord, as per my instruction, my lord. Only I am the candidate, my lord.
Okay. However, the results of the result of the petitioner shall not be declared without the leave of this court.
Very well.
That will be better.
Yes, my lord. I'll appear, my lord, but
Your result will not be declared.
my lord.
What is the list after 3 weeks?
Reply of that.
41.
Meet with the lordship. Very unfortunate, my lord, we have been granted affiliation with the B.Ed college, my lord.
Where is your affiliation?
My lord. And sir. Next
Annexure 3 and 4.
Huh?
Annexure 3 and 4.
3 and 2.
Affiliation in the first year. Annexure 3.
Your lordship wants the application, my lord. Page 26. I am forwarding here with the copy of the Executive Council resolution so and so dated 12/3/20 on the above subject for your information and necessary. You will be required to give. Then, my lord, 27, resolved that the college be granted permission, second year permission to B.Ed and co session 2021 and on the condition so and so and so and so. Then your lordship will go to 28. 28 is the list published by the university, Guwahati University. They have allowed 39 colleges and my name appears as last 39.
Yes.
Hamak College of Education. Then, my lord, we have paid the required
1 minute.
Hamak Rural College of Education. That's
Yes.
Then we have paid, first of all, the processing fee that is 2,20,000. Then now this is the fees for renewal, 65,000 we have paid. Then we have we are continuing, my lord. People are passing out from our colleges for 2 consecutive years. Then, my lord, suddenly by Annexure 7, page 32, my lord. They have published one list where, my lord, our name at 39 has been deleted. It was serially given up to 38. In page 33, up to 38 they have given, my name has been deleted. And before that, my lord, they did not give any opportunity of being heard or any notice that you will be like this. And then, my lord, the university has done it so hastily, so quickly, that your lordship will find 34, annexure, page 34, annexure 8. This is the list of the affiliated colleges under the university to tell, my lord, and our name appears at page number 296, page number 39. Hamak Rural College of Education,
Serial number?
296, page 39.
Mm.
So, in other words, my lord, we are there in the list, main list.
When was this issued?
8 August,
8.
very recently, my lord. And we have come before your lordship very.
How do we get the date? Where's the date?
Page, my lord. Page 32, my lord.
No, 32 is a different thing.
My lord.
But then this page, Annex 8, page 34.
Or 34. That is, my lord, a general notice, the general name of all the colleges we have being out from the university website.
Okay.
Now, my lord, under the provisions of the National Council for Teachers Education, this act, my lord, the core power has been given to the this NCET, and the process is like this, my lord. The university takes the application from us, then it with all the documents, then they process it here, inspect the college buildings and the teachers, everything. Then it's sent to the NCET there, and they send people there, and then after so many formalities, they will either grant or they will not grant the affiliation. Your lordship will find at we have indicated it in our petition also at page 6, my lord. Page 6. Page 6 of our petition, my lord. Page 4, your lordship can see, the university authority has taken necessary step for obtaining the recognition, permission by the NCT, and NCT has granted recognition and sent copy of the copy to the university authority for granting affiliation to the college of the petitioner. The NCT has ultimately granted its recognition permission by letter dated 3/3/2019 and sent to the Guwahati University for allowing affiliation to the petitioner's college. That is minus annexure 2 at page 22. Huh? 20? Oh, I can go to 20?
23.
23, my lord. B.Ed college 2 year, BEID college 2 year. আমার নামটা কোথাতে?
Yes.
Yes. Then, my lord, after that, my lord, you lordship will kindly go to paragraph 5. That the paragraph 5 at page 6, my lord. That the provision for granting recognition of institution offering course for training of teachers education is guided by section 14, particularly section 14(6) of the NCTE Act 1993. The relevant portion the relevant portion is quoted below. Every examining body, that is the university, my lord, shall on receipt of the order under subsection 4, order from the NCET. Number A, grant affiliation to the institution where recognition has been granted. When the NCET grants recognition, or B, cancel the affiliation on the institution where recognition has been refused. Now, my lord,
You are referring to section 14(6).
14(6), my lord.
Yes.
It lays every examining body, that means the university, shall on receipt of the order under subsection 4, that means they when say all the papers to NCET, then the grant affiliation to the institution where recognition has been granted. So in our case, recognition has been granted. So it is the bounden duty of the university to grant affiliation. So we have been granted affiliation.
Yes.
My lord, first of all, my lord, it is a very sensitive matter for the Guwahati University authorities.
And also us.
Number of inquiries are going on, my lord. 2 police cases are pending, my lord, and 3 writ petitions are pending without any stay order before this honorable court. And these things have been suppressed in this writ petition. My
What
lord,
is this?
in WPC
These are
number,
another writ petitions on another subject, my lord, not for this.
no, my lord,
In
same, my
every
lord,
subject we can fight.
that is why, my
writ
lord,
petitions.
this petition should come up along with those 3 petitions, my lord. It starts from WBC 3782 of 2022. After hearing all the sides, my lord, notice has been issued, my lord, but stay order has not been granted. WPC number 3782 public 2022. 794 of 2023 and 821 of 2024. These are pending without any stay order, my lord. Enquiries
So
are
what
going,
are those writ petitions for?
my lord, for my lord, affiliation, recognition by the Guwahati University, and to continuance of their courses. my lord.
No.
Is
So,
the
At
my
least for my lord,
Yeah.
pharmacy education,
Same subject.
PhD, LLB, DLLB education, like that, my lord. These are totally different subject, my lord. Pharmacy education LLB education degree. For that, we have filed those cases. It is a different case, my lord.
These
It is
things should have-
DE, BT colleges only. And then the main thrust is, my lord, this Supreme Court has said that NCTP is the supreme authority to
That,
decide.
that is a settled position.
My lord, that is settled. And for that, my lord, Guwahati University, when it gives the recognition, NCT give the recognition and subsequently give the affiliation, it cannot unilaterally delete the recognition given to a particular. It will have to get permission from the NCT to do that. And this Supreme Court judgment has said that the petitioners, they have invested so many money.
Where is the provision under the NCT, this act, which says that without the permission of NCT, the college cannot be de-affiliated?
That is 16.4, that includes, my lord. 54 says that once recognition is given, affiliation is given, and there is no subject of de-affiliation in the act, my lord. The arbitrary power of the university has acted like that, my lord. Have you do case?
NCT is the ultimate authority.
No, no. My lord, now, my lord, we have it is the state of the students are, my lord, involved. One paragraph I can show your lordship from this judgment, my lord. Your lordship read it so many times. Get them open. This will be a part of it. This is the arbitrary exercise of power by the university, my lord. They cannot do that in the midst of the session, my lord. Here, my lord, these colleges, they challenge the two sections of the Maharashtra College, Maharashtra Act, that prior permission should be taken from the government, then only they can go for permission to set up B.Ed courses, B.Ed colleges. And the Maharashtra the state says that we are not required to pass any. Then, my lord, this paragraph, the High Court has held in favor of the petitioner. The High Court held that in the light of the relevant provisions of the Act, as interpreted by the court in various decisions, the appropriate authority to take decision regarding opening of new colleges as was NCTE, and neither the state government nor the university can act contrary to the decision of the NCTE. According to the High Court, under the Act, the only authority which could take a decision on the in regard to the opening of a new B.Ed college or increase or decrease capacity of the NCET and such decision cannot be ignored by the state authority or by the university. So far as the function of the state government was concerned, the High Court observed that it was in the nature of supply of necessary data and materials to the materials so as the NCET to undertake the process of coming to an appropriate decision, but the state had no power to decide that it had taken a policy decision not to grant permission to open any B.Ed college for the particular period. Such decision was not in accordance with the provisions of the Act, nor in accordance with the law laid down by this court. Regarding role of university, the High Court held that it was
That you've seen.
my lord.
Yes,
Lord,
what do you say? on
Lord,
this?
I won't say that it's a total suppression of tax, my lord, but those police cases, those pending
So is
three
this
cases,
college involved in that police case?
No,
my lord,
no,
it has the, my lord,
No,
relevance.
no.
See,
you don't like.
my lord, in this writ petition also, my lord, Lord, kindly see Annexure 5. It's dated 3 January 2022,
Page.
page 28, Miller.
Mhm. Here the name of the petitioner is there.
28. Then, Miller, page 32, Annexure 7.
No,
Miller-
just tell us on what grounds you have
Miller,
de-affiliated.
there are some developments between this 3 January 2022 and 8 August 2024.
Hmm.
About these 2 years development, Miller, the writ petition is silent. Totally silent, Miller.
No, but you have taken
What
this,
happened in the meantime,
you have taken this decision
Miller,
by the notification of 8/8/2024.
Miller.
No, on what basis have you taken this
That
decision?
is why, Miller,
My
the
lord,
entire
it-
matter should come up along with those
No,
3
no.
pending cases. We have filed affidavits there, Miller. And I will have instruction, Miller. The matter may come up next
He
week
take his
along with-
instruction within
along
2
with
weeks,
these
my lord.
3 cases, Miller.
After
that
2
will
weeks, your
reveal,
lordship
my
will
lord.
hearing.
Let him get his instructions. But Mr. A.C. Bora Gohan, London Senior Counsel, assisted by MS
S not.
S. Nath, London Counsel for the petitioner. Mr. P.G. Fukan, London Standing Counsel, Guwahati University, shall receive instructions. Please again on. When do you want? 28?
Can it be on 30, Miller?
28 is the last day.
20 is the last date of filing. And, all right, my lord, my learned pen says 30.
30,
30, no?
30. Most of that.
My lord, in the meantime, my lord, we have debarred from taking admission. So,
That I'm not I'm not
no,
passing
your
any
lordship
interim
only
now.
say if we may allow us to take provisional admission up to 28. After that, if your lordship see that on 30th, your lordship will cut it out.
No,
All the
We'll see.
persons. Otherwise, after 28, my lord, we will be losing 1 academic year. All the students, my lord.
Okay, then we'll list it on 28. You come prepared on.
Miller,
28.
Miller,
This
it may
matter-
come up along with WPC number
Along with
378
WBC numbers
3782
of 2022,
2020.
WBC 794 of 2023, and 821 of 2024. Correct.
Most of them.
My lord, your
We'll list
lordship
it on 28.
is it,
No,
my lord. Then give us.
28, I'm listing this matter.
Okay, my lord.
After that, we'll pass orders.
But after 28, we will not be able to get.
That's why on 28, I'm going to pass orders after he gets his instruction.
On 28th, my lord, there will be no space for us.
Interim prayer will be, Miller, considered on that day. Miller.
Oh,
I don't
your
have any
interim will be
objection.
considered on 28.
No, then my lord, your lordship can shift it earlier so that we can get 2-3 days time to admit the students. Not on 28th, 25th or 24th.
All these are holidays.
So your lordship will give some, my lord,
That protection, if necessary, I'll give you on 28.
but
Yes.
your lordship will say that interim will be hard on such and such.
Prayer for interim shall be considered on the next suitable date.
Most of them.
One of the list admission part of matter.
Or this part with
Wait, please, Your Lordship. Lordship, I'm appearing on behalf of Mr. P. Mahanta. I'm praying for a short accommodation in the matter, Your Lordship.
you are appearing on behalf of?
Mr. P. Mahanta. Correspondent number 7, Your Lordship.
Okay. When do you want?
Tomorrow or any other hearing day, Your Lordship.
Okay, heard Mr. R.C. Saikal in the council. On request made on behalf of P. Mahanda, the council for the respondent number 7.
7, Your Lordship.
Placed on 29th.
29. Much of it.
3.
My Lordship. So the brief facts of the case is this. The petitioner was appointed as assistant professor on contractual basis in Jorhat Institute of Science and Technology.
Where is that not?
That Lordship. Thereafter, Lordship, actually, the pursuant to an working interview, he was appointed and he joined on 25th of July 2011. Now, Lordship, kindly see the annexer 2, page 25. This is from the principal of the college to the Honorable Minister, Lordship, whereby the application is forwarded, Lordship, for regularization, Lordship. May I
So
read?
where's your appointment order?
Appointment order is, Lordship, ultimately, this was annexed in 2015, that Lordship will find it. The affidavit, when the petition was filed, it was not enclosed. Initially, Lordship, appointment order was not given, but ultimately, put a second. Page 93. Affidavit करो ना 93 है I'm coming to that also, page 93. After joining 2011, finally this order was issued in 2015. Page 93, Lordship. May I read, Lordship? In pursuance of the meeting pending approval of the governing body of JIST, Jorhat Institute of Science and Technology, the undersigned is pleased to appoint Mr. Swenso as an assistant professor of BSc IT department in Jorhat Institute of Science and Technology, Jorhat, on contract basis. The institute is highly recognized his service, sincere service, offering to this institute since 2011. That date is 25th of July, 2011. To the BSCIT as office record said. Accordingly, Mr. Kolita is hereby asked to continue his duties for the next academic session until further notice. The appointment is purely temporary, may be terminated at any time. The salary and other facilities will be paid as per government rule. Now, since 2011, he is continuing. Now, Lordship, coming back to the repetition, Lordship, may kindly have come to page 25. Proposal submitted, Lordship, to the Minister, Lordship, for regularization of the service. May I read this letter, Lordship? It has some relevance. Forwarding an application submitted by the full-time contractual faculty members for regularization of their service. With reference to the subject cited above, I have the honor to forward herewith an application submitted by 6 faculty members who have been extending their sincere service from the inception of BSc IT in the year 2007. Actually, the college was established in the year 2007. And at that relevant point of time, the college was run under the society. And BE course in the year 2009, which speak itself. In this connection, I would like to inform you that the faculties are engaged as per instruction of the second governing body meeting held in the Honorable Chief Secretary's chamber, and they have been offering their sincere services with a nominal remuneration for the greater interest of the student community. And the students are also highly satisfied with their all-round support extended to them as reported by the students. In this context, I would like to inform you that a proposal has been sent by the former principal on 21/5/2012 to the former so-and-so Government Assam for regularization of their service, on the basis of which a file has been put up. File number so-and-so in the prestigious office of so-and-so, but the matter is still in the same state. Therefore, I do hereby request to take action, Lordship. Now, after appointment, Lordship, process has been initiated for regularization of my service. And accordingly, this process has been initiated in this particular file. Now, Lordship, time to come to page 26. From time to time, Lordship, scrutiny committee is constituted for continuation of the service of the petitioner, Lordship. Now, this is one of the order by which a selection committee again constituted. From time to time, their performance is evaluated. And this was done on 22nd May 2015. The institute, since the institute is run under a society, so the principal is the only authority to constitute this selection committee. So ultimately, by this order, the selection committee has been constituted. Page 26, Annex 3. The undersigned is pleased to form an interview and selection committee with the following members for the post of assistant professor in computer science, full-time contractual Department of Computer Science and Information Technology. Lordship, this is very relevant, Lordship. My department is Computer Science and Information Technology. Jorhat Institute of Science and Technology against vacant sanction post to be held on 4th of June 2015 for continuation of service of Sri so-and-so. This is the petitioner who has been extending his sincere service in the Department of Computer Science and Information Technology as assistant professor since 25th of July 2011. Also, although on the date of working interview, he was selected and appointed, but formal order was not issued. But this was done on 25th of July 2011. Till date, without break as per official record. Now, this is the selection committee. These are the chairman and members. So ultimately, selection interview was held. At page 27 is the remarks of the selection committee, saying that he is eligible for recommendation. A note is given, chairman, expert, and there are two members also from the concerned college. Now, government thereafter requested the principal to submit a report that Lordship will find at annexure 6, page 31. This was issued in the month of 8th of February 2018 to the principal of the college for regularization of contractual faculties who are serving in the college. With reference to the subject cited above, I am directed to request you to inform whether there is any rules to regulate the recruitment and service condition of the faculties under Jorhat Institute of Science and Technology to this department at an early date. Now, in compliance of this letter, Lordship, the principal of the college, that Lordship will find at page 32, Annexure 7, has given a detailed report, not only in respect of the petitioner, there are also other faculty members. And when they have joined in which department, what are the requirements, Lordship? So ultimately, this report is submitted before the government, Lordship. May I read this, Lord? Page 32, Annexure 7. The initially in the from paragraph 1, that's in the year 2007, BSc Information Technology Department was introduced in Science College, Jorhat. Presently, it is JIST, Jorhat Institute of Science and Technology, with due approval of Government of Assam. Now, as per direction of DDN so-and-so, the principal Science College spared 5 numbers of vacant posts for BSc IT department and submitted the proposal to the government for necessary approval. And accordingly, government approved the same. Subsequently, in the month of July 2007, Government of Assam appointed only 1 faculty to start the course. But in the BSc IT course, the subjects like accountancy, sociology, English, and electronics are compulsory, and there were no faculties in the said subject available in the college, for which principal appointed 4 assistant professors, namely so-and-so, so-and-so. I skipped the name of the appointees. On full-time contract basis on recommendation of the selection committee constituted as per instruction of the Government of Assam to run the course recently. I'm skipping the paragraph 2 and 3. This is not relevant. This is in respect of that other 4 appointees. Rajiv, kindly come to see paragraph 4. That's in the year 2011, Mr. Rajiv Kalita, the petitioner, he was appointed as assistant professor against sanctioned vacant post in the BSc IT department on full-time contract basis to fulfill the need of the students. A single existing regular technical faculty could not cover the course in time. Now, similarly, paragraph 5 in respect of other teachers, I'm skipping this paragraph also. Now, also can you come to from paragraph 7. The matter was redirected as the Government of Assam to the member secretary JIST Society, High Lieutenant so-and-so, to settle the matter in the GB, and matter was placed before the 5th GB meeting. In meeting, a feasibility committee was formed, headed by the Principal Secretary, Education Higher Department, with other 4 members. As per direction of the Chairman, the Honorable Chief Secretary to the Government of Assam, for scrutiny to the same by letter number so-and-so, June 2016. Accordingly, a feasibility report was submitted by the member secretary JIST Society with reference to letter number so-and-so, 22nd June 2016. Now, that's the minutes of the 5th GB was approved in the 6th GB meeting and resolved to submit a proposal to the government immediately by the principal JIST for regularization of service of 6 full-time contractual faculties. Those have been extending their service since the inception, 2007. Accordingly, the principal JIST submitted the proposal dated so-and-so 2017 with reference to the letter number so-and-so on 9th of February 2017. It may be mentioned that the 6th GB meeting, the society was dissolved as the government of JIST was changed from society to Government of India. What happened also in the year 2016? The Government of Assam taken over the charge of the JIST from 2016. And prior to 2016, it was the society who under which control this institute was running. That in view of the above, the undersigned is pleased to recognize the sincere service with full satisfaction of the students as well as the institute of the above mentioned faculty of JIST, serving considerably for a long period of time against vacant sanctioned post without break. As per government rule, an employee who served in a society for more than 5 years without break against sanctioned vacant post, he or she is eligible for regularization subject to the fulfillment of other requisite conditions. Further, it was next to import.
Yes.
So ultimately, feasibility report is submitted. That pays lordship 45. Now, from annexures 8 to annexure 16, these are the internal communication to regularize the service of the petitioner lordship in the particular file. Now, this is still under process. But thereafter, in the year 2021, Annexure 17, page 47. Now, prior to that, Lordship, kindly come to page 43, Annexure 13. This one of the regulation order in respect of a contractual appointee who are also appointed similarly as that of the petitioner. This was done on 3rd of June 2020. Although Lordship, my case along with other 5 members also under process, but suddenly from that particular file, this regulation order has been issued. This was done on 3rd of June 2020. He was made this regulation order, Annexure 13, page 43. In pursuance of the cabinet decision held on 10/4/2020, the service of Dr. Soenso, contractual faculty of Jorhat Institute of Science and Technology, Jorhat, has been regularized to the Assistant Professor, Accountancy Department, Jorhat Institute of Science and Technology, Jorhat Soenso. So ultimately, his service regularized and continuing. Then we also again approach the authority for our regularization, Lordship. But till that, the process matter is under process. But finally, they did not come to a conclusion. Now, ultimately, Lordship, kindly come to page 47, Annexure 20, page 47, Annexure 17. While the matter was under process, the government issued the guideline in the year 2021 to enhance the remuneration for those part-time contractual teachers. Page 47, Annexure 17. This was issued on 25th of February 2021. Now, these guidelines or terms and conditions for enhance the rates of remuneration for guest or part-time lecturer, assistant professor in polytechnics and engineering colleges of Assam.
Yes.
The guest, ultimately, Lordship, we have.
What's your college?
Lordship.
Where's your college?
No, I am also from belong to engineering college. Now after 2016, the Jorhat Institute now is an engineering college. So our cases are also considered. Now here, let's say, a clause is inserted whereby I am agreed and filed this petition. Let's kindly come to paragraph 3. I am agreed by clause 4, clause 3. Let's henceforth part-time lecturer and assistant professor to be engaged. I am reading only the relevant portion. Let's say. Clause 3, henceforth part-time lecturer and assistant professor to be engaged in the Gulf Polytechnics and Engineering Colleges through a transparent selection process on a competitive basis. Person of in national repute may, however, be engaged directly for a specialist and specific purpose with proper justification only. The part-time lecturer and assistant professor will be engaged against the vacant concerned sanction post. Now, 4, I am agreed by this clause, for which I filed this petition, Lordship. The part-time lecturer, assistant professor must submit an undertaking in prescribed format to receive the remuneration at the enhanced rate that he or she will not claim for regularization of the job without facing APSC as per norm. Now, when the matter is for regularization of a service or in the process, since 2011 till issuance of this letter, suddenly, without any basis, they have inserted this clause whereby they are trying to wipe out my right for regularization. Although the authorities has admitted and I am having a requisite qualification for appointment as a assistant professor in the Department of Computer Science and Information Technology. Now, ultimately, in view of this guideline, 25th of February 2021, I was also selected. That Lordship will find it. Type copy, page 52, Annexure 21. This is the order pursuant to the guideline for enhancement of my remuneration up to 72,000. Page type copy, annexure 21, page 52. This was from the Director of Technical Education to the Principal of the college. Approval of the enhanced rate of remuneration of part-time faculty already engaged by the principal. With reference to the subject cited above, I would like to inform you that as per recommendation of screening committee, 7 numbers of faculties list enclosed as Annexure 1 from engineering program and 6 numbers of faculties list enclosed as Annexure 2. This is important logic. That's a kindly remark is Annexure 1 and Annexure 2. 7 numbers of faculties for engineering program and 6 number of faculties for basic science, computer science and information technology. My subject is computer science and information technology. Have fulfilled the eligibility criteria as per AICT or UGC norms. So as per AICT norms, I fulfilled the eligibility criteria and accordingly I was appointed in the year 2011. Then I am paying rupees 25,000. I am receiving. In the year 2021, the authority enhanced the rate of remuneration up to 72,000. They are allowed to avail the enhanced rate of remuneration of rupees 1,000 per class hour and subject to limit of rupees 72,000 per month. Height Gov letter number so with strict compliance of the terms and conditions mentioned in the guidelines issued by letter number so. Now, rate of remuneration can be drawn by the faculties with effect from the date recommended by the screening committee. You can also request it to collect the undertaking from the above mentioned faculties in the format enclosed herewith and to be forwarded to the office of the undersigned. Now, ultimately, let's kindly come to the Annexure 1 and Annexure 2, page 55 and page 56. Annexure 1, these are the 7 numbers of.
That is not concerning you.
No, this is from engineering program, 7 faculties. My name is approved at Annexure 2, page 56, serial number 6, Rajiv Kalita. And my program is Lordship, basic science, although it is an engineering college, but my subject or program is known as basic science, computer science and information technology. Actually, I'm coming to that, Lord. So ultimately, Lordship, although I have been selected, but since I did not give or refused to give that undertaking, I have not given that remuneration at the enhanced rate.
Till now.
Till now. Because once I give the undertaking, that my right of my regulation that will be wiped out. Although the file has been processed, it is still under process. I am coming to the lot. Now the authorities, although they have only in one aspect, they have filed an affidavit, other they have admitted regarding the part of regularization. Now let's kindly have the affidavit filed by the Director of Technical Education. They only said that although some other faculty members have been regularized, the Lordship kindly come to page 61, paragraph 10. His service was regularized because he is having the norms as per AICT or UGC. But so far the petitioner is concerned from paragraph 11 onwards. May I read this paragraph, Lordship? Page 61. Only in respect of the regularization part, they have filed this affidavit. Paragraph 11, page 61. With regard to the statement made in paragraph 14 of the petition, the answering deponent begs to state that the petitioner has been engaged on purely temporary basis as contractual assistant professor, computer science at Jorhat Institute of Science and Technology. As per Government of Assam in Higher Education Technical Department, Office Memorandum so and so 2016, regarding adoption of qualification and experience as prescribed by the AICT for direct recruitment and promotion of the officers in engineering colleges of Assam, the minimum educational qualification required for direct recruitment to the post of assistant professor in engineering and technology is BE/BTech, ME and MTech in relevant branch with first class or equivalent either in BE or BTech or ME or MTech. Also, as per clause 5.1A of the AICT regulation 2019 notified so and so 2019, the minimum qualification required for direct recruitment as an assistant professor of engineering colleges in engineering technology so and so so and so. Yeah, repeated lots. Now coming to the petitioner has been engaged as a contractual assistant professor in computer science, which comes under program engineering technology, for which as per above government WEM and AICT regulation, the minimum educational qualification required is BE, BTech, MTech in computer science and engineering with first class or equivalent, either in BE, BTech or ME, MTech as per record available. The petitioner is having MCA degree and he does not fulfill the minimum requirement of qualification for the post in which he has been engaged on contractual basis. Hence, the claim of the petitioner for regularization in the post of assistant professor, computer science cannot be considered due to lack of required qualification as per existing norm. Now, this is the contrary stance given by the Director of Technical Education. Lordship, kindly come to page 52 once again of the read petition. The same Director of Technical Education, while selecting the name of the petitioner, saying that his branch is computer science and technology, page 52, and having the eligibility criteria as per AICT norm, page 52, middle portion, Lordship. The same director, Lordship, Director of Technical Education, the name is different, but director is same. The contrary is ten, Lordship. It was done in view of the government notification whereby my remuneration is NS because I am having the requisite qualification. Now in 2024, by filing this affidavit saying I am not having the requisite qualification, that is why I cannot cannot claim or my service cannot be regularized. Although the matter is under process in the department. Now this is
Where is the statement that the matter is under process?
Lordship, the file number is there. Lordship, I'm coming to the Lordship one by one. I'm the affidavit also, Lordship. Now, Lordship, kindly come to. So I'm trying to show that this statement that I'm not having the requisite qualification is contrary to the norms, Lordship. But I'm repeatedly saying my branch or subject is computer science and information technology. It may be an engineering college. After 2016, the name nomenclature is changed. Earlier, it was Jorhat Institute of Science and Technology. Now it's engineering college. They are trying to say that is a computer engineering. Actually, my subject is or department is computer science and information technology. Now I'm coming to the regulation, let's see. What is the qualification? And that I file reply. I'm trying to demonstrate the stand which is taken by the director, the present director is not correct as per the rules, Lordship. Now, regulation 2019, in reply, Lordship, may kindly have the reply to the affidavit filed by the director, page 76. This is the AICT regulations qualification, minimum qualification for a assistant professor, 2019. I'm only annexing the relevant portion, page 76. Lordship, may kindly see 5.1. my program is under MCA, not in engineering college, because it's a computer science and information technology. Now, what is the minimum qualification, Lordship? C. The first one is BA. To that extent, I have no objection. Or BE, BTech, MCA with first class or equivalent in any of the 2 degrees. Or this is the qualification. Graduation of 3 years duration with mathematics as a compulsory subject and MCA with first class or equivalent with 2 years of relevant experience after acquiring the degrees of MCA. I am having this qualification, MCA, Lordship, with 3 years mathematics duration. Now in 2010 also, this AICT regulations, what was the, Lordship, qualification? Page 78 for MCA program. The last part, MCA with first class or equivalent with 2 years relevance experience. So after appointment or at the time of appointment, the selection committee, they have scrutinized the documents or credentials of the petitioner. Ultimately, he has been appointed. And in 2015 also, the selection committee reviewed the process and saying that the petitioner fulfilled the eligibility criteria and he is suitable for recommendation, Lordship, for the said post. So ultimately, he is continuing till that he is serving in the college since 2011 to 2024. Now, the same qualification also prescribed, Lordship. I have annexing some of the documents, relevant documents, from which I can show that for the program MCA, the qualification is Lordship MCA. For computer science and technology, part of the MCA, the qualification is MCA with first class. Now, Lordship, come to page 79. This is one of the, Lordship, advertisement issued by the FPSC, page 79. For filling up 66 numbers of post of assistant professor in 9 different subjects in engineering college. Now, let's say kindly see this serial number 9, Roman 9. Assistant professor in MCA, page 79. Now, Lordship, you will find the qualification in the next page, page 18. Same qualification prescribed. Serial number 9, MCA with first class or equivalent with 2 years relevant experience. Ultimately, Lordship, call letter issued that Lordship will find at page 82 from the FPSC for the post of assistant professor in Government Engineering College, page 82. Subject is MCA. Name of the post is assistant professor technical. And he succeed also. That lot my number or number is what will find at page 86. So ultimately, this
You participated
yes,
in
participated. Lordship. I will call for interview and also participate in this selection. But ultimately, this was abandoned letter. But why I have annexed all these documents to show the qualification as the present director has stated in the affidavit, that is not applicable in the case of the petitioner, because his discipline or subject is computer science and information technology, which is a part of the MCA. And what is the qualification prescribed, as you will also have seen from the affidavit in reply. Page, Lordship, the regulation 2019 MCA with first class. Now, so far the laptop document konto file to the process no আমার যে প্রসেস তো হয়ে আছে প্রসেস তো হয়েছে লাস্ট লেখা হয়েছে
That's an extra. You should not do it.
পার্টিকুলার ফাইল নাম্বারটা আছে না একটু করতে সরি মাই Therefore, my submission is that since the petitioner was appointed in the year 2011, he is continuing till date. And he is having the requisite qualification for regularization that is under process law. So I give you the file number. Yes. Annexure 15, page 45, Lord. In the repetition, page 45. From which file one of my colleagues has already been regularized in 2020. May I read, Lordship? Page, this was 22nd of December 2020. With reference to the subject cited above, I have the honor to inform you that I'm working as an assistant professor computer science in the Department of Computer Science and Information Technology, Jorhat Institute of Science and Technology, Jorhat, on full-time contractual basis with effect from 25th of July 2011 against sanctioned vacant posts as per Society Service Rule. A service regularization file was initially processed by ATA 107/12 under JIST Society. Since JIST was taken over by the state government from Society, moved, a new file was opened for regulation of service by ATA 2003-17 for 6 faculty members. Now, out of these 6 faculty members, 1 have already been provincialized. Now we 5 are left out, but out of 6 faculty members, only 1 Pratap Commerce has been regularized, showing others lack of requisite norms. Though I have full AICT norms from the date of joining. Moreover, our documents have been removed from the file number 7, for which a new individual file, ATA number 2019/19, was opened against me for revival of my service regularization. Now, thereafter,
No, what I want to see is where is the admission of the respondents that your file is in process?
the college authority also given.
No. By the affidavit of the director.
No, nothing. The affidavit is only in one context regarding the regularization. So for the other parts, not a single word whisper, Lordship. Now, that is why I am showing from my reply, the regulation of 2019 ASAT regulation, the APC advertisement, what was the requisite qualification, and the requisite qualification as well as in 2010. My program is under MCA. Department is Computer Science and Technology. Now they are trying to say the Director of Technical Education in 2021 itself says, I'm having the requisite qualification. That's why my survey has been recommended to get the remuneration at the enhanced rate. I am not availing that benefit because I am not giving the undertaking because this is against me. Once I put this undertaking, my right for regulation will be wiped out. That is why I am not giving the undertaking. Now, so far the eligibility criteria, the same Director of Technical Education, the regulation 2019, 2010, it clearly reflects that I am having the requisite qualification for an assistant professor in computer science and information technology. Now, by filing this affidavit, they're trying to say that the nomenclature of the college is now changed. Now it becomes an engineering college. So in the engineering college, the qualification is this is B and B Tech. So I am not a faculty of computer engineering or a faculty or assistant professor in computer engineering. The requisite qualification is B Tech or MEM Tech. But for the program MCA, it may be an engineering college, but my program is MCA. There is no denial. There is no any reply given by this affidavit also. Only in respect of the regulation part, I am not entitled because I am not having the requisite qualification. But which is not at all correct because the regulation 2019, 2010 and the directors Lordship, the given the order of enhancement as well as the APSC advertisement, what was the criteria? And I fulfilled. The APSC also issued call letter. So regarding my eligibility criteria, there is no doubt about it. Now it is only the present director, he is having a contrary stand to all of the above qualification, Lordship, prescribed by the regulation 2019 as well as the director technical. And subject to my formal understanding, I will reply.
Yeah. Made to your lordship. Petitioners again and again reiterated that lordship is pushed this computer science lordship. Computer science and technology engineering. So lordship may kindly mark his submission, lordship may mark it. Just I distinguish what is the qualification. First of all, lordship, the GIST, Juvat Institute of Science and Technology, lordship, is the institute which is governed by the lordship Assam Technical Education Service Rules 1981. So my lord may kindly peruse the rules, lordship.
When did you take over the gist?
Lordship,
2016.
2016, lordship. Before its society modes, lordship, under society modes also, lordship, the society mode also, lordship, all the financial assistance was given by the lordship, government lordship. It was run by the government, but it is under the society. It was in 2015, is a full-fledged engineering college. Lordship. This when Bineshwar Brahma Institute of Science and Technology, that is in Bodoland, lordship, that two institutes was taken as a full-fledged engineering colleges, lordship, in 2015, lordship. So, lordship, the institute is governed by the Assam Technical Service Rules 1981, lordship. Assam Technical Education Service Rules 1981, lordship. It is in page, lordship, 741 of this book, lordship.
Service rules
1981, lordship. Probably page number will be different. Same, no? 741, lordship. 741, lordship. Just regulation part, I am just clarifying. Then, lordship, I will go to the other parts, lordship. My brother has said again and again, lordship, the file was moved for regularization, lordship. That cannot be done as per the statutory prescription prescribed by the 1981 regulation. It's a direct recruitment push, lordship. It by way of direct recruitment, lordship. There is no provisions for adjustment of contractual employee, lordship. There is no provision, lordship. We cannot adjust the employee, contractual employer, ad hoc employee in the lordship engineering colleges, lordship. Even, lordship, TF appointee case was also rejected by this honorable court. We cannot regularize the TF appointee also.
Where is the post?
Lordship. So, lordship, may kindly peruse page 744, lordship. 744, lordship, 5. Method of recruitment, lordship. And my lord may directly come to 5, subclause 5, lordship. May I read, lordship?
Yes.
In the cadre of assistant professor, engineering colleges, workshop superintendent, engineering colleges, assistant controller of examination, librarian, engineering colleges / polytechnic, by direct recruitment in accordance with the rules 6(1) and 18. Here the post is assistant professor. And 6.1 says that, lordship, direct recruitment, it's by the FPSC, lordship. Now it's by the board, lordship. 6.1, lordship.
Then how did you regularize the other?
Other one person was regularized by way of cabinet decision, lordship. Cabinet decision that was beyond permissive under the rules, lordship. We cannot, lordship.
So no, that file under which that other person was regularized.
Lordship.
The names of all these persons went along with his name
Lordship.
in one.
Maybe their name may be there. Their name may be there, or another 2-3 persons' name may be there. But cabinet has regularized by way of cabinet decision one person, lordship. We cannot, lordship, insist the cabinet to regularize so and so person, lordship. It's the wisdom of the cabinet, lordship.
So cabinet can relax the rules.
Why they can violate lordship, they can, whether they can violate or not lordship, if anybody challenge it lordship. But whether the judicial forum or whether my lord can direct the cabinet to adopt a resolution to regularizing lordship. By violating.
That's a different thing. That's a different thing.
Lordship.
But what I'm saying is, for that person, the cabinet decided.
Lordship, not only that, lordship, not only that person, into after coming of the 2005 Act of College Employees lordship, 2010 rules lordship, the more than 351% was regularized by way of cabinet lordship. Cabinet decision that was lordship approved by this honorable court lordship. After the honorable court says that no person should be regularized beyond that particular list lordship. It is a judgment of this our High Court lordship. 356 persons in the general college education lordship. They are regularized by way of cabinet decision lordship. And that was put to challenge before this honorable court, and that was lordship affirmed by this honorable court full bench lordship. That cabinet decision. Even honorable court says that beyond that persons, the authority should not or may not regularize any persons. That is the observation of this honorable court. I am not saying that only this person's lordship. Cabinet may take a decision lordship. Whether that decision is lordship lawful or not lawful lordship. That should be lordship challenge tested before this honorable court lordship.
So what happens to his file then?
Lordship, cabinet has not recommended their name lordship. That is there.
No, the cabinet rejected the.
Cabinet rejected their claim.
Who is that cabinet memorandum?
Cabinet memorandum, today I have not cabinet memorandum. Otherwise, the persons whose service was as part
That's
of.
fine.
That is there.
That they've taken a decision
That
to
is
regularize him.
regularizing.
But then what you're saying is.
Ground of regulation also defined lordship. The particular person is a accountancy department. He's fulfilled the required qualifications. That's why his case was cabinet has approved its lordship. That is the reason lordship. Other thing is that whether that particular person is fulfilled the required qualification on lordship, I will pass that also. Just I pointed out before the lordship that what is the prescription prescribed by the state?
No, that's fine. That's
Lordship.
I'll let you do.
Lordship.
What I want to know is
Yes.
the names of the petitioners who were
Lordship.
rejected by the cabinet.
Rejected lordship.
Who is that rejection order?
Rejection order, if lordship permit, I can
Let us have a look.
call the record also lordship.
After that, the whole thing will come
Lordship,
out.
lordship.
Let's me get this record. Page 43, annex 13. Everything will-
Regarding placing of record, I have no objection. I can place it lordship. Otherwise, lordship, if the file is also moved in the way, then also lordship, he cannot be regularized as part of prescription prescribed by the state. Even he is not the required qualification also, whether he has the required qualification or not, just one page lordship, one page before that, one page lordship I point out. What petitioner says time and again says that he is a professor of the MCA lordship. So my lord may kindly peruse page 79 lordship.
79.
Page 79 of the advertisement lordship. Before that, my lord may kindly peruse page 93. 93 lordship. That was a appointment letter issued by the lordship, the principal is lordship. It says that lordship, second line, professor, assistant professor in BSc IT. My lord may kindly mark it lordship. BSc IT and MCA is a two different lordship component. Two different subject lordship. MCA is a master of computer application lordship. BSc IT is totally different lordship. Master of computer application is a different subject and different branch of engineering colleges, and BSc IT is a different branch of engineering colleges. And it will lordship by perusing the page 79, it will be clear lordship. So my lord may kindly peruse page 79. My lord may kindly peruse Roman 7 lordship. Assistant professor in computer science and engineering. What my brother has said, he is a professor in assistant professor in computer science lordship. Then lordship 9, assistant professor in MCA. This is for master of computer application lordship. And Roman 7 is for assistant professor of computer science and engineering. It is computer science and technology. As part of that appointment letter also petitionized in that particular branch lordship. So what is the qualification of that particular branch? My lord may kindly turn to next page lordship. Roman 7 lordship. My lord got it? The required qualification is lordship B, BTech, ME, MTech, in computer science engineering with first class or equivalent either in BE/BTech or ME/MTech lordship. MCA is not a required qualification prescribed by the AICT for the post of computer science lordship. It is admitted fact that lordship, the qualification of the petitioner is MCA lordship.
Okay. That will consider later.
Lordship,
Heard Mr. A. Dekel and the counsel for the petition.
Only Lordship, these two particular file,
Mr.
because that
A.
page
Gogoi,
54,
the learned
they di-
Standing Council Higher Education shall produce the, where's that cabinet, that regularization?
Yes, page annexer 13. I think. Yes, annexer 13, page 43.
Shall produce the
80.203.
cabinet memorandum
Yes, come.
as well as the cabinet decision held on 10/4/2020 with regard to regularization of the service of one Dr. Pratap Jyoti Datta
Accountants.
as assistant professor, accountancy department, Jorhat Institute of Science and Technology, as well as the records of
Page 52, annexer 21, whereby the director already stated that I am having the requisite qualification. TE/E,
where is that?
page 52, annexer 21. This is the letter whereby I was allowed to have the enhanced rate of remuneration because I am having the same qualification. And they have not denied.
One director may
Yes,
retain one
yes,
thing
how?
that cannot be
Director
lordship,
is same,
that cannot
person may
entitle
be
that.
different.
We have filed an affidavit on oath lordship.
Yes,
No,
On oath, we have filed an affidavit lordship. It's not the required qualification
which
lordship.
file do you want? This
this is
219 or 219 or the TE?
TE lordship.
So the records of
TE
TE
within bracket E A dash
A.
20.
dash 20/2021/2966.
2966 is a letter number lordship. So
Okay.
lordship may just 202021.
থাকিব লাগিব থাকে
2021.
Letter number 2. এই ফাইলটা হইলে দেখি নাই করে।
How long will it take?
2 weeks or 3 after 3 weeks.
This the matter after 2 weeks.
Lordship.
The matter we can be the part of it.
Part heard, I don't know.
Okay.
Since 2021.
Part of
Yes, part
part
of
of lordship.
It's an interim order that may be continued.
interim order passed related to continue till the next.
Ablail.
Lordship.
For item number 32 is concerned, madam. Can it be taken up some other day, my lord? Can it be taken up on 10th of September, my lord?
32.
32, my lord.
Okay, on request made by Mr. D.N. Bhattacharya.
Mine.
General Counsel for the petition.
Ablail.
May I please, your lordship? My lord, I was at page 32, my lord.
32 or
30.
37?
My lord.
Yeah.
No, my lord, page 32, I was just about to finish. It is the $32 million that they have said that valued sought for the valued opinion for the past service benefit of the pension while the board had not received any contribution of these benefits. That they have said, my lord, that I have not contributed to any such kind of, my lord, GPF, gratuity, leave salary, etc. to the board. So therefore, my lord, I cannot be, the board is, my lord, not inclined to take the responsibility of my pensionary benefits. So as this is the view, my lord, expressed by the secretary of the board. Now, this has been again placed, my lord, that page 37, dated 28th of March 2012. This is a letter, my lord, from the Deputy Director of Higher Education to the Principal of the college, a continuous process, my lord, of the interdepartmental, that the counting of past service benefits of pensionary benefit in respect of late Biresh Chandra Goswami, ex-lecturer. With reference to the subject cited above, I am directed to request you to furnish a history mentioning the date of joining, non-sanction, sanction post, did release, resign from the college and final withdrawal refund 50% of the government share by money in respect of late Biresh Chandra Goswami, ex-lecturer of your college for counting of his past service benefits for pensionary benefit within 7 days from the date of issue of this letter without fail as required by the government in the education higher department. So, my lord, they have asked that the 50% of the government share is required to be returned, my lord, from this, which initially they have extended to me, my lord. Now, responding to this again, my lord, at page 38, is a letter issued by the Joint Secretary to the Government of Assam to the Secretary of the Board. Same thing, my lord, regarding application. Now, this is the first application of the present petitioner as a wife of late my lord Biresh Chandra Goswami. With reference to the subject cited above, I am directed to enclose here with a copy of endorsement of Pension and Public Grievances Department along with a copy of the precise regarding the pension case of late Biresh Chandra Goswami, former Controller of Examination, Seba, Guwahati. Therefore, you are requested kindly to examine the matter and submit the views on it for further necessary action. This is my lord Higher Education Department's letter to the Secretary of the Secondary Board, my lord. Now, my lord, may kindly turn to the next page, is at page 39. This is a Deputy Secretary's important endorsement, my lord. Your endorsement at page so-and-so of the file, Pension and Public Grievances Department, after careful examination of the fact, observed that late Biresh Chandra Goswami had initially rendered service as lecturer in Pragjyotish College. Thereafter, he had technically resigned from the college to join SEBA permanently and retired from the said organization as a controller of examination. It has further observed that both the services as mentioned above rendered by him does not fall under the purview of Assam State Pension Rules, Service Pension Rules of 1969, for which this department could not count his past service as well as offer any views for refund of the government share of the CPF as sought for. However, Education Department may take up the matter with SEBA for a decision regarding depositing of the CPF amount and counting of past college service of the deceased employee as per the existing rules and acts of SEBA for extending the family pension and other benefit to the legal heir/wife of late Biresh Chandra Goswami, ex-controller of examination so-and-so. This department has so-and-so. This is the approval of Commissioner and Secretary, Pension and Public Grievances Department. So this is the views, my lord, expressed by the PN, my lord, PG department, my lord. Now, this is again, my lord, communicated by the chairman of the Board of Secondary Education to the Commissioner to the Government of Assam Higher Education Department, Dispur, Guwahati 6, regarding pension of the late Biresh Chandra Goswami, retired so-and-so, letter number dated 1st of February 2017. With reference to the above, I have examined the entire matter regarding the pension, family pension in respect of late Biresh Chandra Goswami, retired Controller of Examination, SEBA. On examination of the entire matter, I feel personally that due to some technical problems, his pension matter could not be settled till date. Settlement of the matter, gratuity/pension of a person is a basic duty of the department concerned, and we have not given importance as required. Late Goswami served in the Pragjyotish College, Guwahati from 5/8/1994 to so-and-so for a, my lord, it should be 64. It has been wrongly typed, my lord. 3/1/1995 for a period of 30 years, 4 months, 29 days. As per the government rule, he is entitled for pension from Higher Education Department, rendering his service for 30 years, 4 months, 29 days. But it appears that his pension from the Higher Education Department could not given as he had not submitted option as per requirement of the existing Act of the Higher Education Department. If the above difficulty can be removed by a suitable order from your end, perhaps his pension can be sanctioned for the period in the Pragjyotish College. He has rendered service in SEBA from 4/1 so-and-so to so-and-so for a period of 7 years, 2 months, 28 days. As per SEBA's pension rule, minimum of 10 years of service is required for granting pension. But considering the hardships faced by Mrs. Goswami on humanitarian ground, SEBA has decided relax the rule of 10 years of qualifying service, and it is decided that pension oblique family pension will be provided on pro rata basis to Mrs. Goswami for the period of service rendered by late B.C. Goswami in SEBA. I therefore request to take appropriate action from your end for providing pension oblique family pension to Mrs. Goswami against the period of service rendered in Pragyotis College, Guwahati. So the copy has also been communicated, my lord. Now, my lord, this is a letter from the Director of Higher Education, my lord, is at page 44, Annexure 12, my lord. My lord, can the factual part is in, my lord, first two paragraph. Even though, my lord, it is important, I am reading, my lord. With reference to the subject cited above, I have the honor to inform you that late Bireshchandra Goswami served as a lecturer in the Pragyotis College with effect from so and so for a period of so and so years, served in SEBA as a controller of examination with so and so for a period of 7 years, 2 months, 28 days, and subsequently expired on 23/11/2007. As per SEBA's pension rule, minimum of 10 years of service is required for granting the pension, but considering the hardship faced by so and so, wife of Lord has decided to provide pension oblique family pension on pro rata basis to Mrs. Aswala Goswami for the period of service rendered by late so and so. Now Mrs. Goswami has requested to make necessary arrangement for pension oblique family pension against the period of service rendered in Pragyotis College. In this connection, it may be stated here that the governing body of the Pragyotis College has allowed so and so to release with retrospective effect from 27/1/1998, and he did not resume service at Pragyotis College. So it is clear that the ex-lecturer lien on the post held by him was terminated, violating the fundamental rule 14A. It is also not clear whether the transit of late Goswami from Pragyotis College to SEBA had the approval of the DHE government as per the Government of India's instruction below so and so, so and so. In all cases where a government servant is to be observed permanently by the foreign employer under his organization, it would be incumbent on him to consult the parent employer before issuing the orders observing the government servant permanently in his service. The order of permanent observation should be issued only after the resignation of the government servant has been accepted by the government and with effect from the date of such acceptance, but late B.C. Goswami was observed permanently in his service by the authority of SEBA without consulting the parent employer as it appears. Moreover, as per the Assam College Employees Provincialization Act 2005 under Section 8, the employees who retired or died prior to 1/1/2005 shall be given superannuation oblique family pension subject to refund government share of the CPF money within 31/5/2006. As per Section 8A of the Assam College Employees Provincialization Amendment Act 2010, the date of refund government share of the CPF money has been extended up to 10/11/2010. But neither late Goswami nor his family member has refunded the government share of CPF money with stipulated time. Hence, the family pension to the spouse of late B.C. Goswami could not be considered as per the Assam College Employees Provincialization Act 2005 till date. However, government is requested to take appropriate action for providing family pension oblique family pension to Mrs. Aswala Goswami against the service rendered by husband late B.C. Goswami in Pragyotis College, Guwahati. This is for your kind information and necessary action. This is a letter by the Director of Higher Education, Milot, to the Principal Secretary to the Government of Assam Higher Education Department. Now this order, Milot, at page 46 came to be passed on 23rd of July 2018. In pursuance of the decision of the board meeting held on 14/5/2018, White Resolution number so and so, pro rata pension is granted in respect of late Bireshchandra Goswami, retired controller of examination, who had rendered 7 years and 2 months service in the Board of Secondary Education Assam, Guwahati 21. Further, the pro rata pension will be continued till the death of the incumbent, that is up to 23/11/2018. 2000, it should be, my lord, as the death occurred on 23/11/2007, my lord. There is a typing mistake, it should be 2007. my lord. Now, my lord, this act I have annexed to show that, my lord, what is the point of section 8A, my lord, as they have raised by the Director of Higher Education, my lord. This is the Assam College Employees Provincialization, my lord, Amendment Act of 2020. My lord, may kindly turn to page 48, my lord. Amendment of section 8A, my lord. In the Principal Act, in section 8A, after the existing provision, the following provision shall be inserted, namely, provided that the period of 6 months within which the government share of contributory provident fund was required to be refunded in respect of the retired / deceased employees under section A, which was further extended for a period of 6 months under this section by the Assam College Employees Provincialization Amendment Act 2010. Herein after referred to as the Amendment Act of 2010 shall further be extended for a period of 6 months from the date of commencement of the Assam College Employees Provincialization Amendment Act 2020, herein after referred to as the Amendment Act, and the intervening period from the date of expiry of the period of 6 months extended under the Amendment Act 2010 till the date of commencement of this act shall also be deemed to have been extended for the purpose of section 8. So, my lord, under this amendment, my lord, that stand of the Director of Higher Education has been negated. Now, my lord, the authority is, my lord, what has happened, my lord, they are saying from the various records, my lord, which reveals that the SEBA is only, my lord, accepting that they are going to give me the pro rata pension only till the date of death of my late husband, my lord. And they are not, my lord, holding the responsibility of paying the regular pension to the petitioner, my lord, which I am entitled if both the services are being clubbed together, my lord. Because, my lord, the Department of Higher Education and the Department of that is the SEBA is both are, my lord, government establishments, my lord. And I have not, my lord, violated any of the provision. So proper channel, my lord. I have migrated from the one department to the another department. So the past service, if I count, my lord, 30 years, so and so months and so days, including, my lord, 7 years, comes to the, my lord, around 37 years of my continuous service without any break, my lord. So therefore, under the, my lord, pension rules, it is a pensionable service is required to be counted, and they are required to give me the pensionary benefits. My lord, it is an admitted fact, my lord, I am retired. I have retired myself from the establishment of the SEBA. So the responsibility of paying the pension or the PPO order is required to be rotated through the SEBA, my lord. But the SEBA is not accepting that, showing that as I could not, my lord, complete the 10 years of service as per their regulation. So therefore, my lord, they are not providing me the benefit of the pension under the rules, my lord. That is my case, my lord. Now, my lord, the stand of the SEBA is.
Yes, my lord, whole history that has been, my lord, narrated here. My lord, I would like to inform you that, my lord, so far petitioner is concerned, my lord, apparently as per our regulation, my lord, qualifying service for pension is 10 years. So
But you took a decision to relax the 10 years.
10 years only because, only because of pro rata pension, because they cannot otherwise relax. Because Lordship kindly see, this is a matter acceptance by the petitioner. Because from petitioner has no grievance against us. Lordship, may I read it, my lord? Willingness to accept return to the SEBA chairman. Willingness to accept pro rata pension, family pension from SEBA in respect of late Chandra Goswami. Most respectfully, I outset, I would like to express my thanks and gratitude to you for your above referred letter, which brought at least some positive line to my decade-long struggle on the issue. I express my willingness to accept the pension, family pension on pro rata basis as mentioned in your letter. Though it covers only less than 20% of BC Goswami's total service period, I welcome the decision because hopefully this decision is bring to an end to the severe part of my late husband pension. And so for the higher education part of this life, 30 years, 5 months approximately service, the decision is yet to come out and nothing has been decided so further in respect of his pension. Sir, I may request you to talk on the issue official with the Commissioner and Secretary of Higher Education and find way to resolve the higher education part of the and earliest. I request the kindly to do that. This part, this letter, etc. I mean, it is extract from our records. I have got the records. Accordingly, my lord, she has willingly expressed, and we have granted prorata pension, and she has accepted. And order is also there regarding the grant of this prorata basis. Action. So, so far, my submission is that petitioner has no grievance against the SEBA. Now, actually, 7 years, 2 months in our department, she is not qualified for any pension. But 30 years, more than 30 years service in the Procedural College, the Procedural College is responsible to give him pension because more than 30 years rendered in the service in the Procedural College. So he became the controller of examination in the SEBA in 1995, and he was in 1995, and he was absorbed in the SEBA in 1997. So he rendered only 7 years, 2 months. So as per our regulation. So as per our regulation, Lordship, as per regulation is not permissible. Even though didn't education minister wrote to the SEBA, kindly do the needful. That's why we have consider her on sympathy ground. The letter has the page Lordship kindly say 107, 106. 106. The regulation on retirement benefit pension of the board, that is 2016. This may be Lordship kindly say qualified service. And next page, Lordship. Yes, kindly see. Yes, page 114. Section 1. Pension. Has your Lordship got it? 114. Yes, madam. Pension. 6(1) temporary. Gov servant who retires after rendering regular temporary service in a pensionable establishment for not less 20 years without being confirmed in any post may be allowed pensionary benefits as available to a government servant. 6(2) every employee, including employees of the tenure post, should have put a minimum of 10 years of qualifying service to be eligible for pension, subject to such regulation as may be applicable in the categories of pension set out below. And now, Lordship kindly see page 115, clause 8. Qualifying service for receiving full superannuation shall be 25 years instead of 33 years. Proportionate pension shall be given to those employees who have completed minimum 26 months periods, that is 10 years of qualifying service, but less than 56 monthly period of qualifying service. In a minimum and a maximum amount of full superannuation period shall be governed by the government of Assam from time to time, provided that in case of an employee retiring on his or her own after completion of 20 years of qualifying service, the qualifying service for pensionary benefits shall be increased by a period not exceeding 5 years, so and so, so and so. These are the regulation, my lord. As per regulation, my lord, we cannot provide regular pension to the petitioner. Is not entitled to qualifying service. Only basis humanitarian ground, my lord, prorata pension is granted, and that has been given to the petitioner. And we have no any, my lord, responsibility to that effect. And also this letter, my lord, I have submitted from the records, my lord. I have record also. This letter she has accepted it. 5th of September 2017. So when she accepted our prorata basis pension, we have given her already. She has no any grievance against her. Only grievance, my lord. He rendered service more than 30 years in the Procedural College. Only technical problem is, I know well, as per pension rule 1969, there is a provision when it's become pensionable in 2005. All colleges employees are pensionable in effect from 2005. There is some option. Those who are opted for pension, they will have to give an option, and those who not opted for pension, they will going on cutting, deducting CPF, PPF, whatever may be, all these things. And that was not with us. That CPF, whatever is deducted from the petitioner during that period, my lord, that has been deducted in the with the college authority. So the college authority is responsible only because of technical ground. He did not offer any option. That was my learned subject to my submission learned by the court of, my lord. That is the problem. So this lacuna can be sold by the Director of Higher Education, otherwise Commissioner Secretary to Government of Assam, Secondary Education Department. Because more than 30 years he rendered in the college and less than 10 years rendered in our Seva. So he is not entitled for any pension, any rules also. And pension and public grants department has a note, they said not qualified. Only that is the position, at that moment, that was not give any of sum. That was extended up to 2020. That was also not done by the petitioner. That is the case, Malad. So I have nothing to say, Malad, because we have already given the pro rata basis pension. That has been accepted by the petitioner by any writing, Malad. So only requested made us to talk with the higher education so that higher education part, that's it, from the college authority, she can get some amount of pension. That is her request. And we have done our part. And that is
Record Malak says.
no. I have gone through the records, I have got it, all these things.
When did the husband die?
Lord, in 2023, 2007, my lord.
This order,
Date?
Yes, my lord. The date is 23/11/2007, my lord.
and page 44 of the deed petition annex 12, it clarifies all these things of higher education. And now prorator pension that is order is annexed here in the deed petition. Page
Last order.
Page
46.
Page 46 is our order, prorator pension has been granted. So no gibbons against us,
Regulation to the
Yes.
So you have accepted the pro rata pension?
My lord, may kindly peruse the language of this acceptance. My lord, it is a conditional acceptance as per my limited knowledge, my lord. My lord, may I read, my lord? What is the conditions I have offered, my lord? The most respectfully at the very outset, I would like to express my thanks and gratitude to you for your above and referred letter, which brought at least some positive light on my decade-long struggle on the issue. I express my willingness to accept the pension of family pension on the pro rata basis as mentioned in your letter, though it covers only less than 20% of late so-and-so total service period. I welcome the decision because hopefully this decision will bring an end to the SEBA part of my late husband's pension.
Yes.
So for
That's what
the higher education part of his service life so-and-so, my lord, the second part, my lord, I have requested the SEBA to make my late husband service as a pensionable count, my lord, because kindly appreciate, my lord, I am not a person with having such a serious legal knowledge. As a widow, my lord, I have seen a dim of light, my lord, that something is coming, my lord. I have given this acceptance as a pro rata, my lord. What is, I have personally inquired the petitioner, my lord, do you know the meaning of pro rata? See, my lord, expressed that I will get some money or the monthly money will coming. Then I have make her understand that pro rata is not like that, my lord. It is a lump sum as a one-time measure they are going to provide you. No family pension. Then my lord, he has expressed that I have in the second part, my lord, I will accept only if the SEBA make the rest part of the arrangement from the higher education department, my lord. That is the issue, my lord. Now, my lord, admittedly, my lord, with all respect, my lord, what my respectful submission is that, my lord, my 30 years, my lord, may kindly appreciate, my lord, my late husband has rendered 30 years, 7 months of service in the Pragyotis College, my lord. That cannot be vanished or goes in vain, my lord. That service is required to be, my lord, give some weightage for the purpose of pension, my lord. There are, my lord, certain judgments, my lord. Actually, today I am handicapped because one of my colleague, my lord, is stuck in the, my lord, this waterlogging problem. He could not bring all the materials for me, my lord, to produce before my lord, my lord. There are certain judgments are also there, my lord, which covers and governs my case also, my lord. Now, my lord, as my respected senior friend has already expressed, my lord, the opinion of the SEBA, my lord friend on behalf of the higher education department is also there, my lord. What is their stand, my lord? What they are saying, my lord, may kindly examine the higher education department parts also, my lord. Regulation process kindly will like.
made clear lordship. It is admitted fact that lordship petitioner is getting the pro rata pension. It is admitted fact that the service respondent is that lordship. One person cannot get a pension lordship from two different departments. Lordship. If you get a pension, that from a one department only lordship. Two parent department or absorbed department, he will get pension either from the absorbed department or from the parent department. It is the service law jurisprudence, and now as per the admitted fact, he is getting the pro rata pension from the absorbed department. Now, as per the submission which was advanced by my brother lordship, lordship has to decide one moot question lordship here in this case. So my lord may kindly note it lordship, whether the petitioner is entitled for family pension lordship by counting the service rendered in the higher education department and from where he will get lordship. These particular questions lordship has to answer in this case. That's because after going through the lordship, all the pleadings lordship and submission from petitioner sides as well as counsel from the Seva side, lordship has to decide the issue whether petitioner is entitled to get the regular family pension by counting the period of service which is rendered by her husband in the higher education department under the Pragyutis College under the higher education department.
Yes.
And one particular document lordship which was annexed in the writ petition is substantiate the issues which to be answered by my lord lordship. So lordship may kindly peruse the document lordship, page 22. It's a annexer lordship 3.
Yes.
So lordship may directly come to lordship copy point number 3 lordship. Copy to lordship 3. The principal Pragyutis College Guwahati for information and necessary action with reference to letter dated so and so is requested to send the service book of so and the amount of CPF due to him to the undersigned with a detailed account of it, lordship. The particular point signifies that, lordship, the period of service which was rendered by the petitioner's husband is taken consideration by Seva lordship while issuing the appointment letter. There is a request to the principals of a Pragyutis College to send the service book along with the CPF amount. CPF amount is the contributory provident fund lordship. It's in
That's fine. That's fine.
lordship.
The issue is this, you have not filed your affidavit also.
We have not filed affidavit, but we are.
Because if this is the contention, at least Seba has to answer to
Lordship,
this, to your contention.
it is their document. Even I go by the act and rules also. What is the act and rules say? If lordship permit, I can file short affidavit. Otherwise, I just place 2 sections of this statute, lordship.
There's no point filing an affidavit at this.
Then lordship, I will place everything on.
But Bhuyan, I don't think we can conclude this argument because you don't have the case laws in your hand.
Today it is not with me, but my lord, I can, in a start date given, I can satisfy my lord.
Even lordship rules also, pension rules also says that. Only just one provisions I am.
You reserve your argument for the next day.
Lordship.
Chutia has already made his argument.
Lordship.
Bhuyan will also. Ishmael also heard.
It will not
He go well and standing.
I will.
I will.
Adi mano Allah, kondogal
Leonard, standing counsel, Seva.
In this case, Lordship, director of pension had no role, Lordship. They have written a letter to ask Lordship.
Pension department as is function is the pension department rule is not there.
Lordship.
Formal party from the donation.
Yes,
Our main document.
When do you want?
My lord, on next week, any date? Thursday coming.
Thursday, some difficulties, lordship. Thursday, no?
Then we'll have it on 5th.
5th September. My lord.
Oblige.
Oblige.
Document I have provided Lordship, let me be kept on record, sir.
Yeah.
By regulation, I will. Thank you. Apply.
7.
Nothing else. Petitioner sells the advertisement of the College project. Petitioner sells the advertisement lordship. Yes, number 15 is a typing of lordship, and 16 is a particular place. The petitioner is a ST, Sidurgas community, SC lordship, and he earlier appointed in the Roha College as a library bearer. Salary was 1,000 rupees per month lordship. After the retirement of Bipul Chandra Das, petitioner apply post was reservation for OBC and MOBC lordship. But he was not is that
This is with regard to that.
That OBC, SC, that roster point, Lordship was pleased to hear it. Lordship, page number 41 is the reservation roster. His contention was that the person who retired belonged to the SC community. So therefore, it should go to the SC community. That is the long and short of my learned.
Where's your senior?
it's out of station today?
This was fixed.
Yeah, so are you ready to argue the matter?
Any other day?
The college is suffering by the.
Let us on request made on behalf of.
I should know.
When do you want?
Next Tuesday, man.
Next Tuesday, when the cases are
Thursday, next Thursday.
29.
Fine. Deeply obliged.
8.
Please, your lordship. Here, my lord, the petitioner was.
Also, here I have received instruction that departmental proceedings was initiated, and that has come to
My lord,
conclusion. Lordship, now the necessary order will be passed. There is a allegation of several misappropriation of funds. The instruction is there. If necessary, Lordship, I will file the affidavit, Lordship.
You file your affidavit?
My lord, that
Not yet.
may not be required, my lord, because here, my lord, we have filed this writ petition. Your lordship may kindly see the prayer, my lord. At page 11.
1 minute.
Second file.
Page 11. First, my lord,
1 minute.
pay balance 50% of monthly salary of the petitioner for the suspension period from July 22 to March 23. So at this so now since the departmental proceeding has been initiated, so the petitioner does not press this part, my lord. The other two prayers are there, my lord. Number 3, my lord, to direct the respondent number 7, in charge headmaster of such and such school to pay 40,000 40,147 to the petitioner, which was spent by him for feeding midday meals to the students from December 21 to 24 July 22, when he was serving as head teacher come member secretary of the school. Then the next prayer, to direct the respondent number 7 to pay 9,080 to the petitioner, which was spent by him in Gunutsav of the school, my lord. So only these two amounts, my lord.
1 minute. Let us see what is here.
Lordship.
Where's the inquiry report?
That inquiry report is not annexed to the lordship.
That you bring it.
I will bring it.
You have not filed your affidavit.
No, lordship.
See that since departmental proceedings is already complete.
Complete.
Now orders are going to be
The
passed.
order has been passed.
He has been found practically order is also passed by this order. Have you got a copy of this order?
No.
Furnish your copy.
Lordship. Today,
Produce the inquiry report.
I will produce the inquiry report. And I will also provide a copy. If necessary, lordship, we will find affidavit also along with inquiry report.
Okay, you file a small affidavit.
Lordship.
MS
SB Chaudhary.
SB Chaudhary, Learned Counsel for the petitioner, DN Sharma, Learned Standing Counsel. Elementary Education Department is allowed 1 week time.
Lordship.
A week's.
I am happy. Headmaster and
My lord, the date may be
is
fixed.
allowed
my lord.
a week's time to file affidavit in opposition. So list the matter on next week will be difficult. We'll have it on 3rd September.
3rd of September, lordship.
Mr. AK Datta, Learned Counsel appears for the respondent.
Not physically my lord.
Huh?
I am happy, not physically my lord.
No, you are appearing for
6 and
Huh?
7.
6 and 7.
respondent 6.
Problem.
9.
In this case, my lord, on last occasion, my lord, Seva, my lord, respondent number 3, I think, my lord, supposed to file an affidavit because action has to be taken by them, my lord. Regarding
Copy was not sharp.
Oh.
They have it. We will have to obtain instruction. Notice my issue, in the meantime, I will obtain.
Notice is already got.
Already issued, 2 weeks time may be given, and he will provide me one extra copy.
Notice is issued, isn't it?
Yes,
Yeah, notice is issued. Heard, Mr.
Hussain.
Learned Counsel for the petition. Also heard, Mr.
G along for respondent number.
J. Alam for the respond number 5.
I am for 3.
On request made by TC Chutia and Standing Counsel Seva. How much time will you require?
2 weeks time.
2 weeks time is allowed to enable him to file, receive
Instruction.
instructions and file affidavit.
Yes.
List
Shiva,
of the-
date may be fixed.
It will come after 2 weeks.
10.
Like, my lord.
Met with the Lordship. This is relating to subsidy matter, my lord. The petitioner is a school, my lord.
1 minute.
21. I have prepared a, my lord, summary. Which I like to salient point. First, I want to read, my lord. This is the second round of litigation.
Affidavit has been filed.
Yes, my lord.
You file your reply also.
I'm fine with prior.
3 and 4. Who are
So, my
two,
lord,
three,
the
one?
salient points I want to place, my lord. Sum up what is the case, my lord. That. What's my kindly read? Should I read, my lord? Shiksha Valley School is a unit of Vidyasagar Foundation Trust having its registered office at Dibrugarh. The deputation school is a service sector enterprise registered on 25th of June 2017 under Goods and Service Tax Act in the Industry Department on 1/8/2018 under MSME Act and also having Udyog Aadhaar number so and so in 18. Government of India announced a subsidy scheme by notification dated 12 April 2018 as Northeast Industrial Development Scheme and it's 2017 for industrial units in the Northeastern region. Section 4 eligibility criteria for 1 unless otherwise specified all new industrial units, manufacturing sectors and service sectors, including biotechnology and hydropower generation units up to 10 megawatt located in any Northeastern region will be eligible for incentives under the scheme. Section 5F, eligible service sector unit is an enterprise in the service sector that significant capital expenditure and has significant employment generation potential. The petitioner school has incurred significant capital expenditure and has generated employment to the tune of 220 persons. There is no mention in the negative list that education sector is not eligible for getting subsidy. The petitioner school, being an eligible service sector unit, had applied for registration under NEETS 2017 on 1/8/2018. In the application form, the registration under the scheme, the column form of business enterprise is in its drop-down menu, contains various forms of business enterprises, including trust and society, and another column of the form, name and address of the cooperative society, chairman, and trustee, etc. On 30th January 2019, the petitioner's application for grant of registration under so-and-so has been rejected. In the second SLC meeting, holding that the school is an entity which is not permissible for commercial purpose. The committee also observed that school cannot be an industrial unit. The petitioner's school is a trust for promotion of education, and as such, the school falls under the service sector industry category of NEETS 2017. In the cabinet meeting held on 28 to Central Cabinet, 2018 at New Delhi, the Honorable Prime Minister and its cabinet has approved the proposal of Department of Commerce to give focus attention to 12 identified champion service sectors, including education service. The trust has school property which is producing or yielding income like any other property, though the business of running of school and also paying tax, GST they are paying. The eligibility criteria defined in NEETS 2017, height clause number 4.1 and 4.2, the petitioner school is not covered by negative list as specified in Annexure 1 of clause 4.2 of the scheme. Clause 5D of the NEETS 2017, industrial unit means any industrial undertaking or eligible service sector unit other than that run departmentally by government, which is a registered business enterprise under the Goods and Service Tax. That the FAO related to NEETS 2017, stating the commercial production, it is the responsibility of the responding authority who has rightly or wrongly included commercial production, probably copied from the earlier scheme, although there is no date of commercial production that in the 12 identified champion service sectors for promoting their development and realizing their potential. In the second SLC meeting of the Empowered Committee held on 38 January 2019 at New Delhi regarding NEETS 2017, the Secondary Department of Education, New Delhi, was also present in the meeting. Therefore, it is evident that the Education Department is also integrated part of the scheme. After submission and recommendation of the proposal by the functional manager of the district, GM, General Manager, DICC, District Industry and Commerce Center, after verifying all the facts and figures, forwarded and recommended the proposal for approval and placed before the SLC. Honorable Court, after hearing the parties in WPC number so-and-so, passed a judgment on 17/5/23, thereby allowing the writ petition and directing the registration under the NEETS 2017 in a period of 3 months. Annexure so-and-so, after receiving the judgment and order that so-and-so respected the prayer of the petitioner for registering the unit and passed an order on 25/9/23 in violation of judgment and order passed by this honorable. Annexure 12, page so-and-so, a copy of the statement showing the numbers of employees as provided employment by the school is about 220%. It clearly shows that the school is providing large number of employment like an industry in the service sector, therefore discriminating the petitioner to get benefit and register under so-and-so is absolutely illegal. So, my lord, I am placing the judgment passed by this court, my lord, earlier. That will, the facts and laws will come. That is on page 62, my lord.
First, let us see the impugned order.
Impugned order. That is in page 74. Annexure 12, page 74. Whereas Shiksha Valley School, a unit of Vidyasagar Foundation, found it, my lord, had filed a civil writ petition number so and so in the Honorable High Court of Guwahati, challenging the decision of the second empowered committee meeting, which rejected the registration application of the petitioner under Northeast Industrial Development Scheme 2017 on 30th January 2019. And whereas the Honorable High Court of Guwahati by the order dated so and so had disposed of the writ petition with the following directions. The respondent number 2 and 3 are directed to consider the application for registration made by the petitioner afresh and pass a reason order therein in the light of the observation made herein above. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. The outcome of the process be communicated to the petitioner in writing. With the above observation, the writ petition stands disposed of, parties to bear their own cost. And whereas the petitioner Shiksha Valley School is a unit of Vidyasagar Foundation Trust having its registered office at Dibrugarh, Assam. And whereas as per the submissions made by petitioner in writ petition, Vidyasagar Foundation has been set as a voluntary society to carry forward the ideals of Ishwar Chandra Vidyasagar in respect of education and social values for the overall development of society. And whereas as per the annexures appended in the writ petition, the Shiksha Valley School falls under the service sector enterprise, and therefore it has been registered under the Goods and Service Tax Act, by registration number so and so, and is also duly registered under the MSCB, Small and Medium Milo Enterprise Act bearing Udyog Aadhaar number so and so. And whereas the Government of India by notification dated 12/4/2018 was pleased to announce a scheme named Northeast Industrial Development Scheme 2017 for industrial units in the northeastern region comprising of the states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, and Tripura in order to boost industrialization. The term of the said scheme was 5 years of so and so up to 22. Under the scheme, the incentives available to beneficiary units included central capital investment incentives for access to credit, central interest incentive, central comprehensive insurance incentive, goods and service tax, reimbursement income tax, reimbursement of transport incentive, and employment incentives. And whereas pursuant to the procedures stipulated under so and so, applicants willing to avail of benefits under the scheme must fill the prescribed application form and requisite documents. The application is verified by the District Industries Center and forwarded to the Commissioner of Industries. Once the state government recommends, the matter is referred to the empowered committee. And whereas it is clearly stated in para 7.3 of NITS 2017 that the final grant of registration in principal approval will be decided by the committee, which will inter alia consider the prima facie eligibility of the industrial unit, availability of budget, and decide the eligibility for registration under the scheme. It is further provided that no industrial unit will have the right to register under NITS 2017 or claim the benefits unless the central government specifically approves it. Therefore, it is crystal clear that the empowered committee is the final authority under the scheme to determine whether a unit should be considered for registration or otherwise. And whereas in order to avail the benefits stipulated under the scheme, the petitioner applied for registration under so and so. And whereas the unit was physically verified by the
Okay.
general manager.
Yes. Where's the cabinet note of
Cabinet.
2017? Have you annexed it?
Yes, yes, my lord. That page, my lord. 107, my lord.
I'll come back to you, Sakya. No, no.
Yes.
There is a for 5 years, my lord.
No, no, no.
7 point
Page 10.
107. And 7.3 is there, my lord. 1 triple 1, my lord.
Hmm?
Triple 1. 1 1 1. 111, my lord. 7.3.
7 point.
3. The final grant of registration, in principle, approve will be decided by the committee which will be inter alia consider the prima facie eligibility of the industrial unit, availability of budget, and decide the eligibility of for registration under the scheme. No industrial unit will have the right to register under niche or claim the benefit under unless it is specifically approved by the central government. No interest on account of the delay in payment of incentive can be claimed by the unit. Therefore, the beneficiary of the scheme has to furnish an
No, no,
undertaking.
this is that notification, isn't it?
Yes,
Of need.
notification. And the
Yeah,
notification is
come to page 77.
70.
70 of the writ petition. Third line. The committee perused the cabinet
The
note.
committee also observed the school cannot be an industrial unit. The committee perused the cabinet note on May 2017.
Yes, where's
to
that note? Where's that
My lord,
cabinet note?
my lord, here is a page. Registration, 114, my lord, of my affidavit.
114.
4. This is the registration.
I'm asking you a question. Where's the cabinet note?
Yes, my lord.
Cabinet note is
Page 38 of the repetition, my lord.
38.
Yes. Annexure 5, page 38. Cabinet approves action plan for champion sector in services.
This is a cabinet note.
Yes, my lord.
Are you sure?
Yes, ma'am.
Okay. Okay.
That is first paragraph, last line, education services. They have, my lord.
Where's that?
First paragraph should I read, my lord? The Union Cabinet chaired by Prime Minister Sri so-and-so has approved the proposal of the Department of Commerce to give focus attention to 12 identified champion services sectors for promoting their development and realizing their potential. These include information technology and information technology enabled service, IT so tourism and hospitality service, medical value travel, transport and logistics service, accounting and finance services, audio visual services, legal services, communication services, construction and related engineering services, environmental services, financial services, and education services. This is the.
My lord,
Okay.
And
champions.
my lord, money also on a earmark for that, my
Yeah.
lord.
My lord, champion scheme and niche scheme is different, and it was approved by different cabinet and different dates, my lord.
This champion sector is not connected.
Not
So that's why I'm asking you, where's the cabinet note?
Cabinet note is not there, my lord.
I want to see that. On the basis of that, this court will have to decide. That's all. Because already court has given a decision to
Yes.
reconsider the case of the petitioner and pass appropriate
Yeah.
orders. Then you pass this order saying that on the basis of cabinet note, we cannot consider his case.
Yeah.
All right.
No.
Consider the case of the school, of the petitioner school.
Yeah.
Now, let us see where is the cabinet note.
Cabinet note, I have stated that it is not related to the niche scheme. And budget is different.
Please read.
Yes,
page
I will
77.
furnish you. Next date may be granted, my lord.
That's
Will
what I'm
furnish.
asking you. Why are you going round now? Third MSN.
And GM has also forwarded the, my lord, claim.
Mr. AK Dr. Leonard CJC appearing for the respondents.
Respond number 1 to 3, my lord.
1, 2, and 3 shall furnish the copy of the cabinet note on NEIDS, NEIDS, comma, 2017 by the next date fix. How, when can you produce it?
My lord, 1 week, my lord.
One, okay, fine.
Okay, I want it from 1 and 5.
One,
Oh, one. No, one
Oh,
and CG two.
Let it be kept as part, my lord.
Oh, no,
Yes,
one.
several times
Oh, my
matter
lord.
is listed, my lord.
I've not
But
heard it properly.
my
List
lordship has
after
heard,
a week.
my- If-
Mr.
And Kali.
N. Kalita, Leonard Counsel, appearing on behalf of Mr. A. Kalita, appears for the respondents,
1 and 5.
one and that's a standing counsel.
Industry standing council.
I'm not one, my lord, 2, 3.
2 and 3. Oh. Mr. So-and-so, Leonard, Uday, A. Kalita, Leonard Counsel, appearing on behalf of Mr.
And Kalita on behalf of A.
M. Kalita, A. Kalita, Leonard Standing Counsel, Industries and Commerce, appears for the respondents, 1 and 5. You produce that note, otherwise matter is very simple.
And date may kindly be fixed, my lord, if possible, my lord.
You want a date fix?
After 2 weeks also, no problem. Let it be on 10th of September.
I fixed many cases. I will have it on 12th September, list on 12th September.
Okay. Obliged. But if your lordship keep it as pardoned, my lord, because the
No,
facts your lordship has heard.
I have not heard properly.
11.
Fixed 12 will hit it.
May I please, your lordship?
Yes.
In this matter on the last day, your lordship has heard in length.
It was
Now, my lord,
You agree?
Lordship, I am for the element. My lord, this
We have
matter
filed
is,
our affidavit.
yes, affidavit and reply, everything is there. Only
When did you file your affidavit?
filed on 20.
You file your reply also.
My lord,
Yeah.
the last day, your lordship has,
20th of June. Yeah, that I've said.
my lord, for not releasing the retirement benefit as well as the pension due to, lordship, in the name of recovery, due to overstay in the service, lordship. My lord, in terms of interim order, now provisional pension has been released. But so far, other retirement benefits, lordship, none of the head has been released, lordship. My lord, first of all, your lordship, kindly come to page 23. Regarding, lordship, date of birth recorded in the service book, lordship, page 23. And 24 is the relevant, lordship.
Yes.
24, serial number 5. Date of birth, lordship, your lordship will find in the right side 23/10/1961. That is, lordship, in the left side, as per affidavit dated 7/11/1990. 24. And I entered into service, lordship, in the year 1999 by producing this affidavit, lordship. Now, lordship, accordingly,
You
in town,
entered into service as what?
my lord,
You entered into service as?
as
the-
assistant teacher,
In the capacity of assistant teacher.
assistant teacher.
So by then you should have your matriculate certificate.
Yes. Subsequently, lordship, I'm going to that, lordship. According to this entry made in the service record, lordship, service book, my date of retirement would be, lordship, 31/10/2021. 31/10/2021. And as per SSLC certificate, that is, your lordship will find at page 13.
13.
13. As per this date of entry made in this certificate, lordship, date of birth is 23/10/1957. Date of birth, and date of retirement would be 31/10/2017.
So as per your HSLC, date of birth is?
23/10/1957. And in
Date of retirement would be?
31/10/2017.
Yes.
Your lordship may also take note in the date of birth as per affidavit, lordship, 23/10/1961. And accordingly, date of retirement would be 31/10/2021. My lord, now your lordship will find, as per lordship entry made in the service book, lordship, I continue with the service. And retirement notice, that is your lordship will find at page 40.
Page
40. My lord, this is the letter issued on 4/9/2019. As per service book, you are going to complete 60 years on 24/10/2017, and hence you are retired on 31/10/2017. But notice your lordship will see, notice was issued on 4/9/2019. At that time, I was in service. Now, lordship, your lordship may kindly come to page 44. Your lordship will clear by this letter.
page.
Page 44, 44. This is the report of a letter issued to me by the block elementary education with reference to the subject cited above. As per above letter from this office number so and so, dated so and so, you receive your reply received on so and so along with your SSL admit card and court affidavit. On verification of the original SSLC admit card, it is seen, it has been observed that your age on 1st March 1980 was 22 years, 4 months, 8 days. That is, your date of birth was on 23/10/1957. That is as per SSLC. And your date of retirement would be 31/10/2017. But your date of birth was quoted as 23/10/1961. That is in the service book as per court affidavit, which is not acceptable. Regarding date of birth of any government employee, the age on SSLC admit card or SSLC pass certificate has been counted to be authenticate, and the retirement date of the employee is calculated as per date of birth in the SSLC admit card or SSLC certificate. Accordingly, lordship, a reply was sought for from me, and they have lordship calculated the excess amount, that is for 22 months. Your lordship, in the second paragraph of page 44, your lordship, thus the reply and documents submitted by your end not found to be satisfactory, and the date of birth quoted in your service book is not correct, which indicate that you have served in your duty against not acceptable documents for excess 22 months and fraudulently drawn your monthly salary from November 2017 to August 2019. Lordship, now this is relating to 22 months. This is the overstay as per the lordship, respondent lordship. And they are lordship calculated the amount, that is page 45, 8,74,582 rupees. My lord, your lordship may kindly come to now. Inquiry report. One inquiry report was prepared, that is page 50. Same thing was reiterated in that inquiry report. Your lordship may not go to that. Now, important page is lordship, page 55. This is the letter of the director to the district elementary education officer. With reference to the subject cited above, I am to request you to submit the following information document regarding recovery of excess fuel in respect of Srimati Ina Devi so-and-so school for taking further necessary action from this end. Original copies of S-proof certificate issued from so-and-so. Original copies of affidavit issued under the seal and signature of the competent authority. S condemnation order so-and-so. Original service book, now 5, lordship, important. Why the retirement order notice was issued on 4/9/2019 by the DO concerned, where mentioning that the date of retirement was 31/10/2017, and whose fault the periodical verification of service book was not done properly during the entire service period of the incumbent concerned, which led to the 22 months of overstay of period in government service, as well as excess drawal of government money amounting to rupees so and so. And this explanation was sought from the lordship, district elementary education officer, because if it is the date of retirement was in the year 2017. Why they are issuing lordship notice of retirement on 4/9/2019? And in the lordship page 58 is the reply of the district elementary education officer. Page 58.
Yes.
With reference to the subject said, I have the honor to submit here the following information regarding recovery of excess to rent in respect of so and so. As per point number 1 and 2, Srimati Ina Devi is not in a position to submit the original S-proof certificate and affidavit issued from the competent authority. Her written statement is enclosed and so for kind perusal of your honor. In the point number 3, S condemnation order is not available in this office, and teacher concerned could not submit the same as the document is not with her as per reported by her. Original service book is enclosed here with as asked for as per letter under reference. As per point number 5, that Madam, the then DO Sonitpur had issued the retirement notice order to Srimati so by number so dated 4/9/19, mentioning the date of retirement of the teacher concerned as 31/10/2017. After receiving the letter from the BO so dated 28/8/2019, as the original service book has been kept under the custody of the office of the BO so, hence periodical verification of the service book should have been done from the then BO so. But whatever they have done, lordship, because if they are taking the lordship that plea that my date of entry is not correct and the document based on which the date of entry was made, that is not acceptable. They could have lordship issued the retirement notice on due time. They did not do it. They have issued this order after 22 months. And this now lordship, this 22 months, whether the petitioner had any lordship fault or misrepresentation, fraud, etc. on his part. Nothing is there. Lordship, on the last day, I have the lordship given on the Supreme Court decision. This decision, lordship, is squarely covered in this present case. Lordship, paragraph lordship 22, 23. Paragraph 22, lordship, may I read, lordship? As noted herein earlier in the service book of the respondent, 2 dates of birth have been mentioned which was not permissible. It cannot be conceived of that the authority could not examine the possibility of 2 dates of birth to be entered in service book of the respondent. They ought to have deleted the initial date of birth based on the matriculation of certificate if the appellants were of the view that the affidavit shown by the respondent was correct and the date of birth appearing in the matriculation certificate must be found to be incorrect. It is needless to say that the affidavit shown by the respondent must be on the basis of document produced by the respondent to show that date of birth entered in the service book initially was incorrect. Instead, the appellant had not issued any notice of retirement of the respondent on 28/2/2002, which was the date of retirement of the respondent on his attending superannuation, or that is on the basis of the date of birth shown in the matriculation certificate. On the other hand, the appellant allowed the respondent to work and co-work for him and paid salary only for the first time. The appellant lordship is the state, took note of 2 dates of birth after he had completed 2 years from the date of his actual date of birth. Same thing was happening in this case. Paragraph 23 and 24 lordship important. Without going into the question whether the appellant was justified after completion of 2 years from the actual date of retirement to deduct 2 years salary and other emoluments paid to the respondent, we may say that since the respondent had worked during that period without raising any objection from the side of the appellant, and the appellant had got work done by the respondent, we do not think fit that it was proper at this stage to allow deduction from his retirement benefits, the amount received by him as salary after his actual date of retirement. 24 lordship, considering the fact that there was no allegation of misrepresentation or fraud which could be attributed to the respondent, and considering the fact that the applicant had allowed the respondent to work and got work done by him and paid salary, it would be unfair at this stage to deduct the said amount of salary paid to him. Accordingly, we are in agreement with the division bench decision that since the respondent was allowed to work and was paid salary for this work during the period of 2 years after his actual date of retirement without raising any objection whatever, so no deduction could be made for that period from the retirement dues of the respondent. My lord, that part has been clearly, lordship, specified in that judgment, lordship. And paragraph 30, lordship, so far retirement benefit is concerned, that has been, lordship, directed to be counted from the actual date of retirement, not from the later date of the retirement. And so far recovery is concerned, that has been, lordship, interfered by the High Court, and thereafter, lordship, Supreme Court has affirmed that.
Otherwise, lordship, this judgment is there. Whatever he has worked, he will get the salary. He has already received that deduction will not be there. But so far as the pension is concerned, pension will be allowed from the date of his actual date of retirement. That is one part. If there is no any misrepresentation of fact or any fraud from the side of the petitioner. But here in this present case, lordship may kindly take up my affidavit, lordship. Page number 64. And here in the judgment, lordship, there were two date of birth entered in the service book, but the same is not the case here.
The ratio laid down is same.
Is paragraph number 7, lordship. Lordship got it.
Yes.
That with regard to the statement made in paragraph so and so, to the writ petition, the answering department begs to state that as per report of the block elementary education officer so, dated so, and block elementary officer Gaburu so, dated so, on verification of HSLC certificate and admit card of the petitioner, it is observed that her date of birth is recorded as 23/10/1957, and as per rule, her date of retirement from the government service is 31/10/2017. But in the service book, her date of birth was recorded as 23/10/1961 by the petitioner on the basis of the affidavit, which is not acceptable regarding the date of birth of any government employee. The age recorded in the HSLC certificate or admit card is considered to be authentic, and retirement date of an employee is calculated as per HSLC pass certificate and admit card. The petitioner has already overstayed 22 months in excess to her actual date of retirement. That this indicates that the petitioner with the malafide intention had intentionally submitted false age proof documents despite having SSLC. He was having the SSLC certificate, lordship, to see the conduct of the petitioner, lordship, and admit card. Despite having the SSLC certificate and admit card, he has given a false date of birth by way of an affidavit. And lordship, he is not a layman, lordship. No, he is a teacher, lordship. He has entered into a service as a teacher. He must be knowing his date of actual date of birth and his actual date of retirement.
Lordship, in the service book, this was prepared by the authority concerned. Where I have
The issue is this: when you entered your service,
yes,
you already had your HSLC
yes, Lord.
admit card.
that is, Lordship, absolutely.
Then why did you file an affidavit?
My lord, they as per their statement, Lordship, the Lordship, their date of birth as recorded in the SSLC certificate was not correct. That's why subsequently that was before, Lordship, they enter into service 10 years back. Lordship, this affidavit was executed.
Why did you apply for correction of your date of birth before the authorities?
That part they have not done. But my lord, I am now the question, main issue involved in this case, whether the petitioner has, Lordship, misrepresented or fraud has committed, Lordship, in this case. The date of birth, Lordship, was recorded in the service book.
The petitioner has not come with a clean hand, lordship.
No.
Despite having his SSLC certificate and admit card,
How can you say that I am not?
Submitted an affidavit.
You have
When did you enter service?
Lordship, service entered in the year 1990. Lordship,
19?
I am giving the date, Lordship. Appointed on 6/12/1999. 6/12/1999.
Okay.
Exactly same thing was happening that Lordship Supreme Court judgment. Here, affidavit was given and one matriculation certificate was there.
There were two.
Same thing was there. Here the same thing.
See,
is there.
Shama,
Lordship.
the issue is this. When you open the service book,
Lordship.
it is the department who will open the service book.
Lordship.
Correct. Petitioner submitted the affidavit.
Lordship.
They could not have accepted.
No,
You
that,
could have-
service has to be entered by the petitioner, the incumbent concerned.
But when the service book was entered,
Lordship.
he submitted his affidavit.
Lordship.
And knowing that he is an assistant teacher,
Lordship.
appointed as,
Lordship.
you could have demanded for the metric certificate.
Definitely.
That you have not done.
That is,
It is also incumbent upon the petitioner to furnish
No,
his
maybe,
being a teacher.
but that you have also not done.
Lordship. Lordship. That is
Then suddenly,
That's
when the
not-
petitioner has overstayed for 2 years,
Lordship.
you just turn around and say you're retiring from 2017.
Lordship.
So now you retire and then we'll come. You have not put the petitioner to any notice also.
That notice part was subsequently, Lordship, when it came to the notice of the
after getting this
department,
lordship is
Lordship.
out.
And
sir.
throughout,
Then,
his-
then
throughout the
that,
petitioner's service career,
then that verification was also done.
no,
It is
throughout
not-
the petitioner's service career,
Lordship.
you having the service book.
Lordship.
At no point of time you raised any question
Right.
before the petitioner saying that why, when your date of birth is so and so, why have you entered this? That also no question.
There is no denying, Lordship, to that particular point.
So I
That's-
think you cannot deduct the
Yes.
2 months salary.
Right.
But so far as pensioner benefit
So
is
far,
concerned,
Yes, pensionary benefit, that's
pensionary
for
benefit
the
concerned
original.
from the actual date of
Yes.
his retirement.
That
That
was
is there, but this is applicable when there is an exclusive fault on the part of the department. Here, this is not the exclusive fault of the
Why
department.
not?
It is
there
legal
is
fault is on the part of the,
there is
petitioner
some
as well.
there is some
and
fault
he
on
has
the
not
part-
come with a clean hand, Lordship.
One lordship may not have may not have
Being a
come with
teacher,
clean. But it is their
Had
duty,
it been
lordship.
a grade 4 employee, it would have been understood that, okay, so far as grade 4 is concerned, we could have understood.
If you
But
want
being
to,
a
if you,
teacher,
if you want to produce some judgments, I can give you time. Otherwise, I'm going to
Lordship,
dictate
otherwise-
the order. I'll pass orders.
My lord, subsequently another judgment, lordship, that is like that judgment also, lordship, or high court.
Lordship, then fix another date.
On the last day, also same thing was happened, lordship.
Lordship,
After
fix-
conclusion of hearing,
after
lordship.
1
they
week, Lordship,
took
we will find it. here.
Okay, heard M. Khan, Land Council for the petition on request by the DN Chairman and Standing Council. Elementary,
Elementary, Lordship.
it's the matter after 1 week.
My lord, maybe as part of lordship, otherwise.
It will come. So I don't want to.
Lordship, 2 days,
Partner-
lordship, twice, lordship, this matter was heard by
Yeah.
your lordship. At the conclusion state, lordship, they are taking time.
18.
Here in this matter, some instruction was received. But the council who was having the instruction could not come to the court today, Lordship, due to this water logging issue. Lordship,
Water
fix the-
logging?
Lordship. Item number 18.
No, I will.
No, no. Instruction to buy.
Dadah,
42 days, no, I will buy.
Let me know, Lordship, kindly see last order, 12/8/24.
Lordship, date.
MSS Chetia is having some instruction, Lordship.
My
I
lord,
don't know.
is the,
And even the brief is also with her. So Lordship may fix the matter next week.
no.
She is having some instruction. So she will produce. She could not come to the court today because of this water logging problem.
A date may be given, lordship, or after 1 week, any date may be given.
Oh, that case.
Part of lordship, chapter 1, lordship.
That's,
12/8/24, Lordship. Last order.
yeah, that's it.
So,
You don't have the
No,
instruction.
Lordship. Today,
Who's having the instruction?
MSS Chetia. Shraddha Chetia. And she could not come to court today, Lordship, because of this water logging. She could not come out. So Lordship may fix any date, Lordship.
Lordship is salary, Lordship. Lordship, kindly 1 minute, Lordship. Lordship pass an order 12/8, last word 24. Pursuant to that order, Lordship, I could collect this order. Yesterday only, this secretary pass an order directing the director to obtain the instruction. Yesterday, how will get it, Lordship? Now, Lordship, see this order. So they were sleeping from March, Lordship, same thing. And the instruction which was sought, that is with my read petition, if in record, Lordship. My absence period or whatever, Lordship.
Today even the brief is also not with me, Lordship.
Different council appearing, this is the problem.
The government has appointed thousands of councils. They are not dealing with the cases.
That is
The reasons.
That is nothing to
Everything.
do with the petitioner.
Every
That
day.
is nothing to do with the petitioner council. It is not the.
This is happening. Every day they are taking some other councils
How many councils are
instructions.
there in the-
In this currently 7, 8 councils also applied. Depend if you lordship go through all that.
Okay, heard Mr. A.C. Ahmed, General Counsel, on request made on behalf of MS.
Lordship day after tomorrow.
MS
Lordship.
S. Chetia.
MS?
S. Shraddha Chetia.
Yes. Chutia. Then it's
Last
done.
occasion, Lordship, it had Mr. B. Kaushik appeared. Lordship. Last occasion appeared B. Kaushik. And he is saying S. Setia, Lordship.
They have sufficient number of standing
yes.
councils. Anybody can appear
Matter
anytime.
is allotted to some.
Again, next
On the
Lordship,
basis of
somebody will appear.
allocation lordship that petition council.
Then
appears.
limited.
So that is nothing to do with the council of the petitioner. Why is entering into that fact?
2nd September.
Lordship, that may be noted, Lordship. Other days, one will claim again this killing, Lordship. If they are doing it
That
from
I've
March,
already
Lordship.
noted on her request where is listing it.
Again, here somebody will come with
No,
the
no.
instruction. This is the problem, Lordship. From March, only instruction from Guwahati they could not obtain, Lordship. Defined it. And taking the
Yes,
Sunday
follow-
also passing the
follow.
order, Lordship.
19 to 23.
Lordship.
You file your affidavit?
Yes, my lord.
Additional?
Yes, my
Does
lord.
it come?
Affidavit.
This one?
Send the affidavit.
Have you taken instructions?
The Bible.
What are your instructions?
My lord, yes, sir, and this Kumar Guru. But they have not agreed to the punishments. And rest are, I think the letters are there. That may be.
So we can close the matters?
Regarding 3 matters.
3 matters we can close it?
Second, that will be.
Can you just say it that's become infructuous or something like that?
And they're becoming infractions because of they have accepted the punishment. They accepted punishment by accepting letter date of 1/4/2024. My lord, one by one, we can say one by one. We can
I can
letter
This
regarding
is honorable court, my lord, if I may, my lord.
Where's that, one for?
my lord, regarding my
My lord, 1/4 order will find in my affidavit, but let me just guide you through, my lord.
No. I don't want to waste time.
My lord, will take up those
one by one, my lord.
rejoinder, my lord. In the
I'm closing it down.
Yes, my lord.
regarding WBC 881, madam. My lord, is WBC 881. WBC
No, you come from WBC 674.
674.
Yash Sharma.
Yes, he is not accepted. He wants to contest the rate.
Yash Sharma wants to
He wants
contest.
to contest.
Okay, 1 minute. Yash Sharma wants to contest.
Okay,
Okay.
just recording the fact. Let him say whatever.
And then Pratum Dixit
He's
accepted.
my lord.
676 has been accepted.
Give me that
Yes.
order one.
Let us see what that order.
1/4, my lord, order is in my affidavit, my lord.
In
Any of the affidavit, my lord can take it up. Probably for the Kumar Gaurav affidavit, which file my lord is having, if I may know.
my lord is in WBC.
I'm on IA.
Your
IA is not there, no?
IA, my lord, is in the Yash Sharma, my lord.
My lord is kindly saying WBC 676, I think.
674.
674, the court is.
1 minute.
674 affidavit.
674, I think.
Yash Sharma.
Yes, sir. Yes, sir. He wants to contest.
Yeah, he wants to. Okay. Anyway.
674 you give me.
So 676. No.
674, my lord, if it is taken.
674 in your affidavit.
Yeah, in my affidavit, my lord, the
Page?
page one, my lord, I'll assist this. 674, it is page number 79, my lord.
79.
9. Please, my lord, if I may read the order.
No need to read it. I'm just giving one
Recording.
small line.
Right.
Mr. S. Sharma in WC 6, 1 minute.
674.
We'll go serial wise.
Yes, my lord.
It will be 676, correct?
674, my lord.
No, 674, you want to contest?
674 you want to contest, you know, 676 the court is asking.
Then 676, my lord.
676, Pradum Dixit,
Pradum Dixit, my lord.
you have accepted.
My lord, in Pradum Dixit, my lord, may say they have
What
filed
is
the
the page
affidavit,
number?
page 165,
Page number one.
No, no,
165.
no, that's,
He says that
One, my lord, let me.
no,
Uh,
1 minute.
I was
Shama,
expelled from institute.
I'm not going into all this.
No. Only,
details.
only that where is the acceptance of that? So your lordship only for the
I've
disposal.
just said that the.
I have accept the decision of BOG.
Hmm.
So he said I accept the decision.
So he has accepted the terms and conditions in the order dated 1/4/2024.
2024.
No,
Yes, my lord.
and therefore matter has become infructuous. Then
Yes.
I'll close it. That's
Yes,
all.
Yes,
Yes,
definitely.
my lord.
Mr. Sharma, this is in WBC
lord,
676.
My lord, only terms and conditions, my lord, except the decision of the BOG. That will get that will proper.
Learned counsel for the petitioner submits that the petitioner has accepted the terms and conditions of the BOG.
My lord,
My lord, the decision of the BOG.
Okay,
my lord, it is not the decision of BOG, it is the order, because the decision is not there, the order is here. The 1/4 is the order which is been passed, the order, simple order of the order dated 1/4/2024 is enough, my lord.
Accepted the order dated
Dated 1/4/2024.
1/4/2024 issued by the head of sections within bracket Students Affairs,
Yes,
comma, Indian Institute of Technology, Guwahati. And therefore, the matter has become infructuous. Mr. A.B. Day,
Yes, my lord.
Learned Standing Council, IIT appears, Learned
Yes,
Standing
yes,
Council appears for the IIT,
IIT.
Guwahati.
Next,
Writ petition is accordingly disposed of as infructuous.
Infructuous.
Correct.
Yes, my lord.
Then what about the IA in
IA is in the 676,
No, no, no.
674, my lord, only.
676 also one IA is there?
676 one IA. That, I think there has become infructuous.
Yes, that one I was there. I was there but to allow him to attend the classes.
No, so I'll close the IA.
I am also good.
Okay, in view of the order passed in the main writ petition, this IA is also this, the IA stands disposed.
I have 439.
Page number
Then next is 879, Kumar Gaurav.
881, my lord, I think.
No, 879.
Kumar Gaurav.
879.
Kumar Gaurav.
Item 31 in the first list.
Kumar Gaurav, my lord, he also wants to contest.
You want to contest?
He will contest.
Okay.
Kumar Gaurav will contest.
Adish Kumar Patra.
This Kumar Patra, yes, my lord, he is also accepted.
Okay, the same order.
Page number, my lord.
Same order. In IA also,
Yes.
same order, closed. And Yash Sharma, Yash
Yashraj
Verma?
Burma, my
Yes, Raj Verma. Yes, Raj Verma, my lord. Yes, Raj Verma.
Yashraj Burma has also accepted, my lord.
He also said that I accept the revised punishment and
Page number 185,
yes,
my lord.
page 185. my
I'm
lord.
closing it.
Yes, my lord.
Same order.
Yes, my lord. Yes.
WBC 1935. Yes. Okay.
Yes, sir.
Then only item that remains is Yash Sharma and Kumar Gaurav.
Yes, my lord.
Correct? So we'll fix a date for consideration of these two writ petitions.
For admission, on admission, as admission item. As
Yeah.
admission item.
No, it is in the admission column.
Admission column. my lord.
But as
My lord, I just want to make one submission, my lord, that may be recorded, that they are all attending classes. And including Mr. Yash Sharma, also, they're all attending, class, doing all recorded. This is my instruction and placing it on record.
The others
Will come for
the
admission,
others
my lord.
I've all closed down.
My lord.
Only two writ petitions are surviving now.
Yes, ma'am.
Item Yash Sharma and Kumar Gaurav.
Kumar.
Kumar Gaurav, my lord.
So in this two, I can record your statement.
Yes, ma'am.
Heard Mr. Yash Sharma, then the counsel for the petition. Mr. A.B. Dale, then the standing counsel IIT submits that the petitioners in both the writ petitions are presently attending their
Classes,
classes,
participating in
are attending
And-
their classes
and other academic activities
And-
which they are
and also participating in other academic
Activities.
activities. Now,
Very good, my lord.
Para-
Is it by statement?
list this
Statement?
matter. When do you want?
After 1 week, my lord. Let it be on next Tuesday.
the matter.
It is at this point of my lord. Next. That is on my lord.
My lord, can it be on 29th if this not,
No, why so much delay, my lord? Let it be on 27th, my lord.
because 27,
27, there are many cases fixed.
unless, because it is just opening on that.
29. All right, man, 29.
Okay.
29th August. Then admission edit. In admission column, my lord.
Oh, it's there in the admission
it is
column
already-
only.
Otherwise, you orders.
Oblige, my lord.
PowerPoint hearing matters.
Forty-two of supplementary list, admission.
Right, pleasure, Lord. Matter relates to pension matter, Lord.
Hmm?
Pension matter, Lord.
Pension or area salary?
Area salary.
Area salary.
Affidavit filed.
Lordship, affidavit, we have received instruction.
Let's see your instruction.
And DI of school has already resubmitted the proposal.
I don't know what you are doing. You're just sending the proposal, you send it back again.
Again, there is a mistake on that, that while calculating the area salary, inadvertently they have included that DCRG and leave encashment amount, that's part. So that rectification is being done. By 22nd, the DI school will furnish again the corrected proposal. That instruction we have received from the DIF school as well as from the direct.
So what do you want today?
Lordship may fix the matter after 3 weeks, Lordship. By the time that proposal will come from the DIF school on 22nd, as they have stated. And now the director will process and send it to the government for
Third,
next
Mr.
sanction.
L. Hussain.
L. Hussain.
Yes,
Learned
Lord.
Counsel for Petition. Mr. B. N. Sharma, Learned Standing Counsel, Elementary Education Department submits that the earlier proposal for error salary in respect of the petitioner submitted by the Deputy Inspector of Schools, Charaidio, had some mistakes in as much as the amount of DCRG and leave engagements were also included in the said error proposal. Stop. He submits that the corrected error proposal would be sent by 22nd of August 2024. Stop. He therefore pressed for 3 weeks' time to enable him to receive further updated instructions. Praise the Lord. List after 3 weeks.
Let's kindly date maybe fix.
It will come. 2023 met.
43. Lordship, this matter pertains to family pension. The notice was issued on 13/10/23.
13/10?
23, madam.
Yes, Shama.
Instruction is awaited, Lordship. And perhaps
What is taking you so long?
that private respondent also agent
No private respondent.
Is this admission column?
admission. So, Lordship may fix the matter after 2
Or my lord, may I pray for direction to dispose of my representation. My representation is lying
Your
with the
representation.
page 31, my lord. It is lying with the district elementary education officer. I have submitted all papers. Now the DEO will send the proposal to the director of pension, and the director of pension will take up the final call.
नहीं तो petition नहीं है
You want this representation to be disposed of?
My lord. Because my lord page, if lordship peruse page 23, there is an order passed by the director of pension to insert my name in both health of PPO during the survival of my husband. Now the only task is to finalize the pension in my favor.
Yes,
Lordship, direct to dispose of this representation by the DO. And
In a time bound manner.
You are the second wife.
My lord. Second wife, but after the death of first wife, he
Okay, heard Mr.
M. Ali.
M. Ali on the council for the petition. Also heard Mr.
I appeal for 1 and 2.
1 minute. Also heard Mr. G. Begu, learned government advocate, for the respondent number 1 and 2. And Mr. B. N. Sharma, the understanding council elementary education,
for 3 and 5.
for the respondents
3 and 5.
3 and 5. Finance,
Final.
Mr. H. Alia, the understanding council finance department, for the respond number 4. Stop. Para. The petitioner is the second wife of late Abdul Kashim, who retired from service on 31/12/1995 while serving as head teacher of Fakuli Maktab LP School. Stop. LP School under Fakuli Education Block in the district of Nagaon, Assam. Stop. Thereafter, comma, where's that pension PPO?
PPO, my lord, I have annexed.
Given the husband?
Page 16, my lord, the PPO. A type copy is there, my lord, page 13. PPO, page 13, my lord.
Thereafter, comma, the petitioner's late husband was granted pension by PPO
One three, my lord. It starts from 12. PPO number is page 13.
by PPO number PPO/E/1067
Six.
10676 on 21/11/1996 with effect from 1/1/1996 by the Director of Pension Assam, correct?
My lord.
Stop. The petitioner's late husband continued to receive his pension, his full pension, till the time of his death on 1/1/2023. Stop. After the death of her late husband, comma, the first wife of the petitioner of late Abdul Kashim, namely Shrimati Manuara, correct?
My lord,
Manuara Begum was permitted to enjoy the family pension. Stop. However, comma, the first wife of the petitioner's husband also died on. No, no, no,
no, my
no,
lord.
no, no.
Manuara, Firoza Khatun.
Not Manuara.
Firoza Khatun.
Shrimati Firuza
My lord, Firoza Khatun did not get family pension because the husband was alive. Husband was getting pension. After death of Firoza Khatun, this petitioner marriage took place. Now the husband died and the petitioner claiming for family pension.
Oh, okay. Then I'll say like that. In the meantime, don't say the husband of the petitioner's late husband, huh? Continued to enjoy her, continued to receive, started getting full pension. Stop. In the meantime, the first wife of the petitioner died on 29/3/2004. Correct?
Lord,
Stop. Thereafter, comma, the late
last.
late uh, late Abdul Qasim married the present petitioner. When did he marry you?
Date of marriage, my lord, I
On-
have not found it.
You have not filed.
But after the death of first wife,
After married the petitioner. Stop. Thereafter, comma, the petitioners let us thereafter let Abdul Qasim died on 1/1/2023. Stop. Stop. After the death of her husband, comma, the petitioner applied for family pension before the director of pension Assam oblique respondent number
no, my lord, this is district
District Elementary
Education
Education Officer, Lord. Representation has been
is
submitted.
31.
no, I'm not coming to that. Approach the director of
yes, yes,
pension
yes,
Assam oblique respondent number 2. However, the petitioner was directed to make a representation before the district elementary education officer, Nago, along with all the relevant documents. Stop. And where that
Representation.
in the meantime, the respondent number 2, by a communication to the address to the treasurer officer Nago, requested to insert the name of the petitioner. This is not required, I think.
Not required.
Cancel it. Stop.
Last line, not it.
Accordingly, comma, the petitioner made a representation before the district elementary education officer Nago, Assam on 26/9/2023, praying for payment of family pension due to the death of the petitioner's late husband. Stop. The said representation dated 26/9/2023 is yet to be considered by the district elementary education officer, Nago oblique respondent number 3. Stop. Para. Accordingly, this writ petition is disposed of, directing the respondent number 3 to consider the representation made by the petitioner on 26/9/2023 and draft pass appropriate orders in accordance with law after verification of all documents within a period of 1 month
1 month from the date of
from the date of receipt
receipt of the certified
of a
copy.
copy of the order of this court with the aforesaid
Obliged.
applications and damages. Writ petition is disposed of.
Obliged. 24 of Delhi League order.
Please, Your Lordship. This is review application, my lord. Very short point has been involved in this case. Lordship has decided that the past services of the petitioner should be counted in the selection process. We are the existing worker. And however, at the same time, Your Lordship come to page 246.
Yes.
My lord, fourth line from paragraph 18. My lord, fourth line down.
No, you are on which review petition?
Both the review petition arise from the same judgment, my lord.
No, no, but you are saying 246, page 246.
246 is the upper. 240, not 246. I'm sorry. Starts from 233 and operative portion is at 245, madam. Paragraph 18, madam.
No, 245.
Fifth line from below. Therefore, in the considered opinion of this court, the past service of the petitioner should be counted. But however, considering the fact that petitioners in both the writ petitions have already participated in the OMRQ written examination without any protest, this court is not inclined. So our case is that, my lord, before participating in the selection process, we have protested the advertisement by filing writ petition.
Where's that?
We have also annexed separately, my lord. Next, page 247, my lord.
Huh?
Order starts from 249.
249,
49.
okay.
Second paragraph, my lord. Petitioners herein are serving as assistant professor of Dhemaji Engineering College under Regulation 3F of the Assam Public Service on ad hoc basis and are aggrieved by the notice under reference number dated 21/2/2023 issued by the chairman of the Assam Engineering Service Recruitment Board. Invited application from the permanent residents from Assam having for recruitment of 61 number of posts. So this advertisement we have challenged before participating in the selection process. And so Lordship, see the operative portion of this order is at page 261.
Yes.
Last paragraph. However, it is made clear that any appointment to the sanctioned vacant post of assistant professor in Dhemaji Engineering College to which the petitioners and LS2 in this petition on so and so, they were appointed on those sanctioned posts on ad hoc basis in terms of the selection made on the basis of the impugn advertisement number so and so dated 21/2/23 issued by the chairman of so and so shall be subject to the outcome of the writ petition. That writ petition is still pending, my lord.
Still now?
Yes. So there is an order that appointment will be subject to the outcome of the writ petition. So my submission is that before participating in the selection process, we have protested by filing this writ petition and the issue is still pending. However, your lordship has held that since there is no protest before participating in the selection, therefore perhaps we are not entitled to our past service. Although it is not clearly indicated that whether we are entitled to or not. But if we read both the lines together in the judgment of your lordship, it says that past services should be counted. However, since we have not protested, therefore we may not be entitled. We need a clarification that since we have made a protest before participating in the selection, so our past services is also to be considered in the instant selection process. And they are continuing with the teaching proficiency test, my lord. And then in respect of engineering college, that 22nd is the last date of Viva, teaching proficiency test. 22nd is the last date. They are continuing with the teaching proficiency test, my lord. 22nd is the last date for engineering college. So if
Yes,
after that, our petition will become infructuous.
Lordship, just now I clarifying Lordship what my brother says Lordship. Earlier writ petition was Lordship, not challenge the Lordship the past service part Lordship. Their main pair is that in this particular case Lordship.
no, issue is this. This court has already come to the finding
Lordship.
that they are entitled to
Lordship.
the what you call
Past service, counting of
past service, counting of past
Past
service. But then this also court also said that this court is not inclined to
Lordship.
interfere with the 21 to 2023
Lordship.
because they have participated in the
Lordship.
process without any protest.
Lordship.
So inadvertently, this court has had made that observation.
It is not inadvertent Lordship. It is not inadvertent. It is as per on the basis of the record Lordship.
No,
If
because
Lordship,
they've already
if
challenged
Lordship
the
finding is
advertisement.
that, if Lordship finding is that they are entitled for the past service, then we have to go for appeal or review Lordship. Yes, because there is a Lordship observation is that they are not entitled for the counting of the past service mark. That's why we are not prefer appeal and review. The engineering college are suffering Lordship last 3 years Lordship. Almost Lordship, the writ petition is pending before His Honorable Court almost 2 years Lordship. The order was recently passed. So state has Lordship, abide by Lordship's direction. We are not going to challenge it Lordship. What Lordship has said, we accepted it. Now we are going to complete the selection process. Yes, because otherwise AICT is going to cancel our Lordship the recommendation part Lordship, recognition part. And Lordship's finding is
Where
on
is
the
this notice 21 to 2023?
Is the advertisement.
and Lordship's finding is Lordship on the basis of the record. They are participate in the selection process without any protest Lordship regarding qualification.
No, they are saying that they have protested by
They
the
have
earlier.
filed, not the Lordship not the past service part. Their petition was in respect of that they are continuing the TF. That's why advertisement should not be executed, should not be come to a conclusion, and they should be regularized. That is their case. That is their case before the single bench of that particular case which was pending Lordship. Now we are preparing leave petition also for appoint their party, appoint the selected candidate. Their case was before the single bench is there. As because they are appointed in the tier. That's why they should be regularized instead of going to the direct recruitment Lordship. Otherwise, that particular issue was already settled by Honorable our High Court, division bench, full bench, and single bench also again and again reiterated that tier person cannot be Lordship regularized Lordship. In the final hearing, we placed that judgment Lordship. Otherwise, their case was that Lordship. Lordship, there is no error apparent face of the record in the Lordship judgment. Whether that particular judgment is reviewable or not, that part first Lordship has to decide Lordship. In my considered opinion, there is no error apparent in the face of the record. Lordship's finding is on the basis of the records, which was materials available before this honorable court, and this was not a judgment for review Lordship. And for review, how Lordship has exercised the power of the review. Lordship is already well aware that part and reiterated again and again by the Honorable Apex Court. Lordship.
Let us see this 21 to 2023.
Page 87. For assistant professor.
There were 4 notices, isn't it? Yeah. Four advertisements.
For engineering colleges, technical, one advertisement. For non-technical, another advertisement. Polytechnic, technical and non-technical. So therefore, there are 4 advertisements. So all our remaining clauses are same, my lord. And page 89 is the process of recruitment. The recruitment process will comprise of basically.
What was the challenge in the first writ petition?
Challenge was that, my lord, since we have been appointed under 3F and there was a notification of this by the state of Assam that our appointments are approved. My lord, can you see page 72? 72. Although this was not a ground in the writ petition that whether
That was not a ground, it is admitted fact. There are cases that was as simple as there are cases that they are appointed under 3F regulation or APSC. So their service should be regularized instead of going to the direct recruitment. That was their case, Lordship.
But
and as per Lordship's judgment, Lordship, the findings of the Lordship, we are not objected. The observation and direction which was given by Lordship, we are satisfied. If Lordship's finding is that they are entitled for the marks for counting of the past service, then you have to prefer the appeal. As because that was a entry level point, Lordship. Entry level point, HT notification, today I am again reiterated, Lordship. Although we have agreed with the judgment pronounced by Lordship, abide by the Lordship's direction, this is a entry level point, there is no scope for Lordship counting of past service, Lordship. Entry level point. As Lordship has already held, and there is no any adverse impact in the state of Assam, Lordship. So we are not preferring an appeal, Lordship.
Let us see this.
Otherwise, we are ready for appeal, Lordship.
Let us see the WBC. If you want to go for appeal,
No,
we
no,
can go
Lordship,
for
no.
appeal. There's
No,
not
no,
an issue.
no, no. What I am saying, Lordship.
That's
what-
not an issue.
No, no. What I am saying, Lordship, I am saying is that we are abide by the Lordship's direction. We are satisfied the Lordship's direction. And Lordship's direction is on the basis of the material of the records. There is no error in the apparent in the face of the record.
well, your lordship
If
has
there
said
is
that-
no error apparent in the face of the record, then Lordship's judgment is not a reviewable judgment one. This is my
That
submission.
part will hear you.
This is my submission.
Let
Lordship,
me be
yes.
satisfied with
Lordship.
the review petitioner.
My lord,
Where is the judge? Where is that order that writ petition which you have challenged
yes, my lord.
the advertisement?
Page 249, my lord.
64, isn't that?
64 is the advertisement.
No, no.
249.
249.
The long order. I want to show that we have challenged the advertisement before participating. We have challenged on a different ground, my lord. It has been to Lena. It is photo finding through. Moving to them. I'm taking working on it. 24. Photograph 24. Photograph 24. And photo present to government photography. Yes.
Yes.
The ground of challenge is based on notification
3F.
page 85.
You're saying that you have been appointed to 3F under Rule 3F of the Public Service Commission. Then you have undergone a selection process.
Yes.
And therefore the notice of 21/2023.
Yes.
Because you cannot be permitted to undergo another selection process. And under 3F, you have been appointed against a sanction post.
Yes.
And therefore you should be regularized, correct?
Yes.
That's all.
That court has examined the matter and there is a order that any appointment may be subject to the outcome. But the fact is that we have challenged this matter, we have protested. And your lordship, your lordship's finding is in our favor. But your lordship only see page 2245. Once again. Therefore, in the considered opinion of this court, the past services of the petitioner should be counted. It is in our favor, my lord. But the next line, if we read conjointly, however, since we have participated without protest, therefore, that was inadvertent. Therefore, perhaps we are not entitled. And their subsequent notification reveals that yes, there is no provision.
No, you read it properly. However, considering fact, the petition board read petitions have already participated in the Omaya MCQ.
Without any
Yes,
protest.
written exam, without any protest. This court is not inclined to interfere with the 4 notices.
Yes.
I didn't give a direction that the 2 years service should be counted, should not be counted. This court made an observation that the petitioner's past service should be counted. However, since you have participated in this court is not interfering with the notice 21 to 2023. Supposing if this court comes to the finding that that despite the protests,
yes,
this court is not interfering with 21 to 2023.
Interference, my lord, that part we have not even challenged in the.
Will it make a difference?
Yes, my lord, because then your lordship perhaps hold that we are also entitled to our past services in the selection.
No, that part what I can do is that we'll keep it open to the government to take a decision.
Till then, my lord, they may not declare the result because 22nd is the last.
No, I'll pass the order now.
Because 22nd, my lord.
I'll pass the order now. I'll just modify this by saying that, I'll just modify that there was no protest. This one I'll remove it. But for the purpose of counting past service, the matter is left open to the respondents to consider the case. To consider your,
My humble.
that's all.
Can it be
But
taken up?
otherwise, I have no objection.
Can it be taken up tomorrow at whatever your lordship's convenience?
Tomorrow, I have
Can we-
any everyday lordship is taking a decision, lordship.
Lordship, they
Now
have
they are
said
20
that AG will appear, therefore. we
As
are
he will not
expecting,
appear,
my
so
lord.
I am standing here, lordship.
But
As he will not
however,
appear.
on the last occasion.
As
also
he will not,
they said
they
AG
are advancing the argument, lordship.
In a way, they are
Otherwise,
continuing with
our
the fiber. my lord.
lordship
That is
have
our
passed
style.
any order, our argument part will finish today, lordship. Our argument part will finish today. What is their pair in the writ petition?
I'll just modify this 4 lines
My lord.
by expunging these 4 lines and then saying that, however, the question of whether granting past service is left open to the respondents.
In the previous
all.
line,
If modification is that particular way, then I have no objection. Otherwise, their pair is absolutely lordship says interfere to allow their pair. So lordship kindly page 67. What is
So
that?
what this court is finding is that I've made one observation without any protest. So at least they have filed a writ petition
They have,
challenging
they have filed a writ petition on a defined footing, lordship.
no, maybe,
They-
but they had challenged that notice of 21
Challenge
to
part is
2023.
one thing, lordship. Challenge part is one thing. Pair part is one thing. And what is before lordship's part is another thing.
See, because that
Lordship.
writ petition is not before this court.
Writ petition is not before this court, and that fact was lordship in other way, lordship. That is in respect of TF appointee. So their basic pair is that, as because they are the TF appointee, their
So
service
see-
should be regularized, lordship.
There's shortage of time.
Lordship.
Now from 22nd, I don't know what you were saying. Interview is
fiber
starting
will be over, my lord.
or your.
If lordship's observation is that way, I will not advance my argument, not a single point I will advance my argument. Otherwise, lordship,
I'll just modify this line
lordship.
by saying that these 4 lines are expunged.
No.
However, the issue of granting past service to the petitioners, the matter is left open to the respondents to
That
consider.
part, lordship, I have no.
Previous line, my lord, your lordship has held it. The petitioner's past services should be counted.
Huh.
Since we have participated with protest, we are also entitled.
That's why this without protest, I'll remove this.
My lord.
I'll remove this line.
Lordship, this is not
Only that
written.
modification part is there, I will not submit. Otherwise, it is not a case of review, lordship.
Lordship, take it up tomorrow, my lord. My senior will be appearing. in the-
Okay.
Only that part, short point, my lord.
Tomorrow, if you can't take it up, then this review will become infructuous. Isn't it?
Day after tomorrow is this last file.
Tomorrow, then we will on merit, lordship. Tomorrow we will argue on merit, lordship, whether review is maintainable or not. I am not agreeable tomorrow that order which was proposed by lordship. I will advance my argument on merit, lordship.
They are at liberty.
Go away.
Lordship.
Council is not very confident.
Lordship.
His senior is there. Senior is not appearing today.
Lordship.
At least let the senior come.
Otherwise, lordship proposition, lordship's findings is lordship, we are all accepted, lordship. There is no error, lordship, and its judgment is not a reviewable one.
No, my proposal is you can
Yes,
tell
ma'am.
you can tell your
Yes, ma'am.
senior council
Yes, ma'am.
that I made a decision that I'm passing this order.
My lord.
Let
is
him
a-
come with any argument, but I'm
It
passing.
can be
the
passed
order.
tomorrow, my lord.
In his presence, I'll pass it.
Lordship. My
It's just a question of 1-page order.
lord, my lord. That is our,
Okay, on request made by Mr.
it cannot.
H.K. Nath, Learned Counsel for the review petitioner, list the matter again on what is tomorrow, 21st.
Lordship.
Lordship may fix it at 3 o'clock or 3:30. A short one, so that can be taken up.
At 2 p.m.
My lord.
2 will.
Lordship, lordship.
Obliged.
Lordship.
26, hearing.
That's some other day.
Yes, my lord, yes.
Now this hardly 15.
My lord, as per when the less cases, my lord, on that date, this matter will be fixed. Because last couple of days, my lord.
Heard
Uh,
Mr. B.K. Das, Learned Counsel for Petition, also heard Mr. Architect Chowdhury, Learned Assistant Solicitor General of India. Release the matter again on. See, next
Less
week,
matters on a
28,
particular.
30, the many cases are there.
Lordship, except on 28th and 29th, any other date.
Maybe we can make an attempt on 50.
That's fine with me, Lordship.
My lord.
My lord, I'm
Obliged.
sorry, my lord, I beg to mention two urgent matters, my lord, 34 and 35, my lord. Any convenient date, first week of September, my lord.
34, 35 on request made by Airbnb and it comes to the petition. This the matter only. Is a hearing matter?
Hearing matter, my lord.
First week, many cases are there.
My-
Now also I have fixed 5th. How about 10th?
10th. May it please your lordship, my lord. I beg to mention item number 27, my lord. I am appearing for Mr. Senior Counsel, Mr. P.K. Tiwari, my lord. It's a part-heard matter. I humbly pray that this matter may be taken up on 29th, my lord, subject to your lordship's convenience, my lord. It's a part-heard matter. The respondents have been asked several times to bring the records of the case and guidelines for holding the DPC, my lord. Long pending case. It was also, and after they submit their, bring the records, we'll also submit written arguments also. Can it be on 29th, my lord?
Who is appearing?
My lord, councils change from time to time, my lord. On the last occasion, I have the order. CK M. Sharma appearing on behalf of Mr. CKS Borua. MS M. Sharma, Mr. M. Sharma. Order dated 23rd of July.
Oh, government advocate.
Yes, my lord.
Any government advocates today? No. Okay.
Okay, any other day, today, not any other day.
Okay.
Any other day.
When do you want?
29th, my lord.
List the matter.
It's a hearing date. That's all. Obliged.
May I please, your lordship? I beg to mention item number 33. It may be fixed on next week, my lord. Actually, this matter is some urgency is there. It will hardly take my
Mr.
A. Ahmed.
33.
Yes. It will take hardly 10 to 15 minutes.
Heard me say on request made by, yeah, but.
Next week, my lord. Any date, man, next week.
29th. 29th.
Obliged, man.
Item 20, can it be taken up on 5th of September, my lord?
Which?
Item 28, my lord.
Okay.
5th of September.
Who appears for petitioner?
I am for the respondent of 4, my lord.
List the matter on 5th.
Obliged.
Item number 29. Maybe listed on Thursday, your lordship, or otherwise Tuesday next week,
Tuesday, Thursday,
if possible Thursday.
3rd September.
Lordship, item number 30, it cannot be fixed on 12th, lordship. It has been listed for 4 or 5 occasions, but
Yeah, 12.
12 September, item number 30.